Right, good morning everyone. Let's start the class for today. few things I wanted to say before we dive straight to the class. I texted most of you during the weekend. Some of you, maybe a few of you I didn't text because you only started the class a bit late. You probably joined a few days ago, something like that. So I haven't texted some, but most of them I texted all of you. But I haven't replied all of you yet. Okay, I haven't replied all of you yet. I make sure that each reply that I text all of you, I give you my personal suggestions what you should do. So I take my time in order to reply you. So I will reply the rest of you. It's still in my phone. Okay, I will reply them by this afternoon and give you my suggestions what you should do. All right. I think by now, first thing also like I said, I'll make a WhatsApp group for all of you by end of this month. Second thing, I think by now, all of you most probably have started to settle down. No issue on assessing the notes. Okay, no issue on assessing the recordings. Quality, everything that's fine. Okay, so that's the good thing. And you will have a good idea what is it like for CLP course. Which I say it's very different from your LLB course, okay? And I said your approach must be different, isn't it? So I think by now you will have an idea, oh, CLP looks like this, okay? Now, I want you to take another 2 to 3 weeks for the next, so what's the date today? So I'll come to you all again on the first week or second week of October, probably second week of October, about 10 to 12 that weekend. And I wanted to know what is your time management plan and also your study plan for it. Now, I think you all know how it feels for a CLP course. The next 2 or 3 weeks is for you to find out how you should manage your time to study, how you should plan your study plan. Because now some of you said that you're not sure whether you should come into live classes or should you come into watch recording. Some choose to come into live. Some said they prefer recording because they can pause. Okay, yes, fine, it's up to you. Some said they wanted to make notes. Some said they have a little bit of problems reading the statute, the skills. Okay, I understand. I listen to all the things. Okay, it's normal for beginning because it's very different from your LLB course. So you have to get used to it. So that's why we start slow. I keep saying that we haven't go into 4 full class yet, even though we conduct 4 class per week. The reason why I say that is so far we have second week. This is the third week. Even if you see last week we have Monday civil, but Monday still we just read statute. Tuesday, okay, we have a class where we have cases to look at, Legal Profession Act. Today we continue. And Wednesday we have fraud and misrep, isn't it? Fraud and misrep. And Thursday we have, what is it again, Thursday? Sorry, Wednesday we have, Thursday we have back to civil, isn't it? Today we continue PP. So by end of this month, you will see how it feels for full class where each class we are packed with notes. Not every class we have so many cases to read. Last Tuesday, I have a list of long cases for you. Not every class like that, so don't worry like you think that, oh my God, every class I have 20, 30 cases. No. Sometimes whole week we don't even have one case. Sometimes maybe one class we have 1, 2 cases. Sometimes we don't. Sometimes maybe one class we have 10, 20 cases. Okay, not so many. The Legal Profession Act, last one on Tuesday, you have more cases because it's the whole set of Legal Profession Act case. So by end of this month, you will have an idea how it feels. All right, for the full course. Okay. Okay, for the full course. Then I want you to have your plan how you want to manage your time and study, because some of you I've spoken, you have a little bit of issue on managing your time because of you're a matured student, or some of you are working full-time. Okay, so now I wanted to guide you how you all wanted to solve this kind of issue, because like one of the students I talked to yesterday talked about, she was thinking should she make notes or not. She shared a lot of her uni journey where it's all open book, and this is the time where it's a closed book. Okay, it is a closed book. So I haven't really gone through every single one of it. That's why I didn't reply you, but I will reply you. Okay, but I'll reply you. So don't worry, I'll reply you this afternoon. So come out with your study plan. There is no one size fit all approach. Okay, no one size fit all approach. So if you need some advice, suggestions, what you can do, you can always ask me. By taking another 2-3 weeks, you will really fully settle down with how you manage your time. Because some of you said they will, weekday, he will go through one time the recording, weekend, go deeper into the recording, meaning he watched 2 times. Yeah, up to you, which one you fit best. Some like to come live classes because you wanted to be disciplined. Some prefer recording, okay, because you can pause and jot down. Okay, so take another 2-3 weeks, you will have a proper study plan. Now, when you make your plan or your time management, always focus on two things, okay? Number 1, productivity. Number 2, efficiency. When you do this thing, does it increase or make you much more productive person? When you do this thing, would it make you much more effective? And I wanted to share with you what I share with one of the students. Actually, I did this every year. I have a student that asks me this same question. So she asked me that she prefer making her notes because when she make her own notes, she feel, in Chinese we call 安全感. Okay, in English we feel that it's like you know, what do you call that in English? You feel not safer. You feel the kind of feeling you feel, you know, guaranteed. It's like I did something. Now I said you can do it, but you can also use the notes I gave you. But whatever decision that you make, the decision you make, okay, must make you much more productive and effective. If you think by spending 5 or another 6 hours a week to make extra notes, make you much more productive and effective in learning because you can simplify the things you learn in class, you learn faster, then please do it. But if you think you spend 5 or 6 hours extra a week to make extra note, it doesn't make you a much more productive or effective. It just makes you feel some kind of, you know, that kind of emotional guaranteed safe. I did something. Then to me, it's a waste of time. It is not useful. It doesn't help at all. Okay? I'm teaching you all this not just for studies. Whatever you do in the future, in your career as a person, father, or a friend, husband, whatever, okay? Do something you focus on productivity and effective. And you look at solutions. Now, I think some of you started to find a little bit of issue. How to manage time? Should I study at night? Should I study at the weekend? So once you have an issue, what is it you focus on? You focus on solutions. Don't dwell, okay? Don't dwell and stuck there on issue or problem. A lot of us we always stuck at issue. We kind of stuck at the emotional and issue or problem, so big problem, okay? Yes, there's always problem, but what is the solution? How do you plan to solve it? So whenever you ask me a question, I always ask you, how do you plan to solve it? What's your solution? Okay, then we can discuss the solution. All right, this is what I want to talk for the first 5-10 minutes on this one. All right, so take it another 2-3 weeks, and then you will fully settle down with your time management and study plan. I think now first 2 weeks, assessing them, getting a feel of the CLP course, I think it's there already. All right, so I'll come to you again in another 2-3 weeks, and I'll reply most of you by this afternoon, and I'll discuss with you. Now, the second thing is with regard to the internship. I know some of you are matured students, so I wouldn't suggest internship because you already got a work and family. Some of you are actually also working in a law firm, so I wouldn't suggest you to do it because you do it. Now, some of you I've spoken to, and I said I want you to consider whether you want to do internship or not, so that if you prefer to get some experience, then we can discuss and see how to proceed with that. And I also said that you can take another 2-3 weeks and then make your decisions when I come and speak to you by early October. Because right now, I said, because we are not yet in that four full class yet, okay, where every class is packed with information. So by end of this month, you'll feel it, and maybe you think that, I do not want to do some kind of work because I wanted to fully focus, because even though it's only 4 classes in Danish class per week, but then you know there are cases to read, there are things to do, isn't it? So I want you to consider. Of course, I highly suggest you to do it if you think you can cope, because you learn something else you cannot learn in class or uni. And but if you think you wanted to fully focus to study, then okay. So we talk more about that. So I already give you the suggestions and the options. So try now to come out with your own way of studying, make notes or no make notes, how should you make notes, okay? Then after that, you think about that and I'll kind of speak to you in 2-3 weeks time. Now the third thing, of course, is if you need any suggestions on what to do, you don't know, then feel free to text me. Now, if you all got any questions, I know this may not be something that you used to do during your LLB days, but are kind of different with them, right? If you have any issues, okay, I always sit. I know some of my ex-students will know this. If you have any issue regard to studies that you don't understand, you can send me a text. Okay, you can send me a text, no problem. Don't be shy. Don't be shy. You can send me a text. I will reply you once I'm free. I may not reply you immediately, but I will definitely reply you. I will definitely reply you within 24 hours. Okay. So for example, last year, I can tell you, last year, full course plus revision course, we have a total about 100 students. So sometimes I may not be able to immediately, but I'll definitely reply you. Okay, I'll definitely reply you. So if you have any issue that you don't understand, after listening to the recording and notes, you still don't understand, then okay, please send me a text. Now another thing is I always tell the students, any one of you, because don't ever leave the problem until last minute only start to tell me, or else there's very limited things I can do for you, okay? If you start to find that you are going downhill, like you're losing concentration, you're losing motivation, you feel that you're starting to give up, you feel that, it's so boring, you don't want to do CLP anymore, you feel that you cannot concentrate, please tell me immediately. All right, please raise it up with me, text me, and then this is what I feel. At least we know that it's an issue there, at least we can find some kind of solutions together. Because if you don't do it, then it will roll bigger and bigger and drag. By the time you realize it's already April, May next year, and too late for us to do anything about it. Okay? Like I said, September, a lot of you are very motivated and come into class. By October, if you see like the first class when coming like 20 plus 30 students, I said in 2 weeks time half of it, so you can see now it's half of it already, and probably by October another half of it could go. Now maybe you find the way you wanted to learn, you want to watch recording, yes, no problem. Even if it's one student or no student, I still conduct live class, no issue for me. Okay, don't worry about it. So find a way. I don't restrict you, you must do this, you must do that. Everyone has a different learning style. But if you have any issue, don't understand, you can text me. And if you find that you are not coping well, mentally, emotionally, please talk to me. I do appreciate all my students each year. Some of them, they tell me really, I think I shared with you all, some of them tell me really personal issue to me all the time. I think they trust me. So, and I keep it very confidential between me and you. Okay, it's something only me and you, and I make sure I give you my suggestions and opinion and solutions, what you can do with that. All right. Okay, that's what I want to say. I hope everyone is clear. So take it another 2 weeks, 2-3 weeks, and then you will know what's the best way for you to study. All right. Because now we only started 3 subjects, and by November we will come in criminal and evidence. The reason why I do civil and PP first, because it is a bulky subject, lots of things. So I wanted to clean it, take it off the system first. Okay, clear it off. Right. Other than that, contract and tort is a much smaller one. Right. Today we do professional practice. Okay, let's have a look at your professional practice. Now, first thing first, thank you for one of the students that point out one of the mistakes that I made in professional practice. Now, if you look at professional practice, right, okay, this is the part, right, your recordings, okay, I actually make a mistake there in the labeling of your cases. If you look at the case, this one, so if you look at here, I actually said updated. We re-upload the updated. So you can download this one and delete the old ones. And for all the cases that we put here, the zip file, for all the cases that we label as 1.9, you change it to 1.7. For 1.9.1, you change it to 1.7.1. So basically, it's the part that we are doing today here. I actually wrongly labeled it as 1.9, okay? It's actually 1.7, 1.7, and 1.7.1 to 1.7.1. So all 1.9 you change to 1.7, all 1.9.1 you change to 1.7.1. Okay? So this is also 1.7, 1.7 because it correlates in here. I'm not sure what I do. Here 1.7, and this is, I think I changed here this one also, 1.7.1. All right? So this is what we will do. And today we will do 1.7, 1.7.1, and 1.8, and then we'll finish Legal Profession Act. Okay? So just to give you an overview what we have this week, today we have PP, we'll finish this, then we are done with Legal Profession Act already. Tomorrow we will have general paper, discharge and remedies. Okay, tomorrow will be full class because there are some legal principles and cases I wanted to go through with you. Alright, so tomorrow might be a little bit heavy, but not many cases, probably about 5 or 6 cases, but there are some principles I want to go through with you and I'll explain why tomorrow. On Wednesday, we will have civil procedure. We will still read statute together because this is the last class we read statute. We finish off reading statute for civil procedure. Then on Thursday, we come back to PP. Okay, it's always civil, PP, GP, civil, PP, GP. So last Thursday with civil, so today PP. Okay, it's always like this flow until November. Then once we finish a general paper, then criminal evidence will come in. So on Thursday, we will have a PP. And PP will move into the new one. We'll move into ethics rule. And I'll give you a set of notes there. Okay? But for ethics rule, don't worry. It's quite straightforward. This is the one. Sorry. What am I doing? Okay, ethics rule, we'll come into this ethics rule and we'll go slow and it's quite chill one. So Wednesday and Thursday class will be chill. Wednesday we read statute, Thursday we'll read the ethics rule. It's very easy one, ethics rule. But then you have to memorize something. Okay, it's very straightforward like pendidikan moral. Okay, it's like pendidikan moral. And I'll tell you how you should approach the exam question. So we will take 2 classes for this chapter. So I don't want to go heavy. I don't want to go too fast. So Thursday we do 1 class here and next week 1 class on this one. So maybe next week the class on ethics rule may not be a full 3 hours. Maybe we'll finish early. Then we can finish early. Because I don't like to combine half of everything. So it all tidy with you. Okay, very tidy and organized. Now we are 2 weeks into the class. I hope that you arrange the class according to what I suggest you, because I don't hope you download the notes based on, you arrange based on date. Don't arrange based on date. Or else the more we have the cases and then you start there, you're confused already. Oh my God, this case is when? This class is when? Okay, arrange it. Remember how I teach you on the first day of orientation? Arrange it based on the file numbering, based on the chapter number. Okay, chapter number, and you have clear-cut notes, each chapter number, how many sets of notes. Because sometimes we may need 2 classes to finish this, 2 classes to finish this, 2 classes. Sometimes maybe 1 class to finish this. So don't arrange it based on class name or class date, or else you have too many. Okay, so when you revise, then you know. Okay, then you go back. So that's why you see how I put it here. So you see that chapter 1, 1 out of 2. So that you know there is 1 more class, which is today, and then we're done. Okay, now let's start with the class today. Okay, take out your statutes. We'll read statute together first. So we'll read particular section 94 onwards. Okay, disciplinary proceeding, it's very often tested. That's why I wanted to dedicate 1 class to this one. Very often, almost every year. It is quite the main part of your Legal Profession Act. It is about if a lawyer did something wrong, what can the Bar Council do? Disciplinary. as it suggests. So you will have to know the procedure on disciplinary proceedings. Okay, what is the power if, let's say, find that the ANS is liable? What can the bar counsel do? And also, can the lawyer go and appeal? And what is the appeal process? What are the cases in there? Can he go for judicial review? So today we go through all those things. Okay, now you flip open to section 94. I'll share also my iPad with you. Where is the disciplinary proceeding? Okay, e-statutes or your physical statutes, anytime when we are ready. This one we'll look at it later on. So basically I summarize briefly the procedure here for you. Okay, so you can read it. So I'll just read the statute together. So let's start with section 94, 93, 94 there. Okay, I'll make it bigger. Right, so that's a good one. Okay, now this is a disciplinary board. Okay, who does it consist? Okay, never mind. Okay, let's look at section 94. Now you will need to know this one. Any advocates and solicitor. Now in Malaysia we call it advocate and solicitor. In UK you call it barrister and solicitor, isn't it? Barrister is the one that you go to the court. Litigation. Solicitor is where the one that you do the documentation. They separate it. I think Hong Kong also separate it. You know, you always watch the movie. But here we don't have. Once you're a lawyer, you can go to the court. You can do kind of documents. It's up to you. So that's why we call it advocate and solicitor here. Who has been guilty of any misconduct. So what is the meaning of misconduct then? Here, so today we will see the definition of misconduct. Guilty. Who decides he's guilty or not? The disciplinary committee. Okay? Shall be liable. So these are the possible punishments that the bar counsel can, or should I use disciplinary board? The options, the punishment, the penalties, the disciplinary board can exert, can put it on the ANS. Struck off roll. When are you on the roll? Am I on the roll? Yes, I am on the roll, even though I'm not practicing now, but I'm on the roll. So if I want to practice, I just need to fill in the form, submit, pay the money, then I got the license. Of course, it has to be parked in certain law firm, then I can practice. Because I've been called to the bar. So once you pass the CLP exam and you pass the long call to the bar, then your name is on the roll. But your name is on the roll doesn't mean that you are an authorized person, you know. Your name is on the roll doesn't mean you're an authorized person because you didn't practice. Only when you apply for a practicing cert, then you are an authorized person. Then you can call yourself a lawyer. Okay? We talk about this in authorized that thing. Okay? To be suspended from the practice for any period not exceeding 5 years. To be ordered to pay a fine not exceeding 50,000 or be reprimanded or censured. Okay, I think straightforward, you all understand. Now, for the purpose of misconduct, what does it mean? So then they give you a list. Criminal offense. So for example, Alex, as a lawyer, was being charged for murder, or being charged for theft, or being charged and liable, found guilty for voluntary causing hurts. So, okay, conviction, convicted. So in criminal, we use the term convicted. Breach of duty of court, including failure by him to comply with undertaking. What is undertaking? Then we look at in the chapter 3 when we do duties of counsel. Undertaking means a promise that you give to the court. For example, you by right should come to the court today, but you didn't come. You immediately call the court and judge and say you were so sick that you cannot make it out from the bed. And you promise next week when the court resumes, you will come back and you give in your MC cert. Next week, you come in already. You didn't give. Then the court, where is your MC? Where's the undertaking? The promise that you make to the court. Okay, so there is a breach of duty of undertaking there. And if there is a breach of duty of undertaking, what are the penalty? The judge, when we do duties of counsel, you see that this is very academic, very boring stuff when we do duties of counsel. There are 7, 8 big topics there, but very dry and boring. So I'll take 2 classes there, but you have to bear with me. It's very dry. If you think it's too dry, you don't want to come into the live class, please feel free to do so. Go and do something else. Like I always say, enjoy your process as a student. Don't have to be so strict, have to be like this, like that. You think, I'll just watch recording. Why cannot? Okay, why not? You don't have to force yourself to sit here. All right, as long as you discipline, finish the class and know what is your goal, okay, to pass the exam next year, then fine. So we will do that. Duties of counsel, what are the punishment? Okay, it's a very dry and academic stuff. And also C, dishonest, fraudulent conduct in the discharge of the duties. Okay, now fraudulent here. Remember fraudulent misrepresentation? Okay, same thing, fraudulent, fraud. Maybe you took the money of your clients. Breach of any rule. You see this. Not next week. On Thursday, we will start with the ethics rule. Remember I said about the LPPER, LPPR, SAR, SARD, okay, SRO. Those kind of rules that the Bar Council make where the lawyer must comply. If you breach those rules, you are susceptible. You can use the words susceptible. Okay, susceptible to disciplinary proceedings. So you must comply with those rules, like those pendidikan moral rules. Bankrupts, because once you're bankrupt, you cannot leave this country, you cannot be a lawyer, you cannot be a politician, all these things. Okay, we'll talk more about this when we do insolvency. Then after that, you can read on your own. Accepting employment in any legal business through a tout. How do you pronounce it? Tout or tout? Tout, I think it's tout. Now, meaning, we do this in ethics rule, meaning, let's say you are a lawyer and I say, hey Alex, I got a lot of clients on my hands, business deal. I pass to you and work, but I wanted to have a 30% of the legal fees that you charge. I'm not a lawyer, I'm not a lawyer. I'm just a marketing guy. A lot of things like this going on in the practical scenario. Now, even though you by right cannot do it, but I can tell you, outside in the reality practical scenario, 99% of you did it like this way. Okay? Right? We'll talk more when we do ethics rule. Allowing any unauthorized person to carry on legal business in his name without his direct immediate control as principal. You will see this quite often with, not often. In reality, this is what happened. In where? Property agency. So you will see those big property agency because they have so many agents, right? So they close a lot of deals, but they wanted to take a part of that share of legal fees. So they have buying power. So they will go and approach lawyer and say, you practicing or not? You using a license or not? Not using, you go and apply, then you park. I open up a law firm, we share. So basically, then they will hire some junior lawyers to do the conveyancing, and then they shared the profit. I've heard this many times already, many times. I think even there are some people that try to approach me and ask if I can do it for them. So I say no, I don't do it. All right. Then breach of carrying indirectly any profession, trade or business, calling which is incompatible with your legal profession. Do you know that once you're a lawyer, you cannot be doing any other else? Okay, let me ask you. A lawyer working full-time in the morning and night-time be a MLM agent, sell Amway, can or not? By right, cannot. Does anyone follow? Well, that's up to you. Okay, you know. Right, if they wanted to do it this way, can or not? They still can. If one morning work morning full-time, night-time work Amway, they will need to write into the Bar Council and get their permission. The Bar Council doesn't allow a lawyer where they have a second job that is incompatible with their profession, because you see, morning like tie, wear a coat, evening you sell Amway, that kind of, what do you call it? In Chinese we call it 反差感, that kind of, how do you call that? Like total opposite. So they feel that it doesn't reflect the professionalism of the profession itself. Okay, the profession itself. So let's say you're a lawyer in the morning, nighttime you teach class law, can? Can, because it's still within. So that's why you see a lot of lawyers. That's why you see college, the classes now I think is at night, if I'm not wrong. Okay, most of them are at night, like ATC or BSc, because they are lawyers. So morning they have to work full time, night time they come into. So they can. Okay, they can. Right. So this one, you can read the one, the rest on your own. The one I wanted to show you is this one actually. This one, sorry. Okay, this is the main one. Sorry, not C, D one, this one. This is the main one. Now, so you can, this one, easy to read, nothing so hard. Now, I want you to focus on this one. A pilper shall mutatis mutandis be subject to the same control by the DB by virtue of section exercise in ASN, and any reference to A and S in this part shall mutatis mutandis include a pilper, but in lieu of an order of striking him on the roll, suspend him. Alright, order may be made prohibiting from proceeding any petition until the date to be specified order. For the purpose of this section, pilper includes a person who has completed the prescribed and yet to be admitted to an A and S. So once you are a chambering student, you are susceptible to the same disciplinary proceeding rules in this LPA. Same like an A and S. You have to abide and follow all the ethics rules as well. If you don't abide, you shall, mutatis mutandis is a Latin term, means, how should I explain it? Means, let me Google and see what's the first. Means it shall equally applies to you lah. I think shall use that. Okay, it shall equally applies to you. Okay, mutatis mutandis. So you see that subject to the same control equally applies to you. But if you are found liable, can they have the same punishment like here for you? This one, 94 sub 2. No, because your name is not on the roll yet, isn't it? You are not practiced yet. Of course, it maybe ask you to pay fine, but normally won't. But the most obvious way they will punish you is to probably put a caveat or suspend you from admission. If you look at your sections 17, remember we talked about 17, entering of caveat against admission. Okay, put a caveat. And let's say put a caveat, then they'll be notified once you call and they will object. Or maybe when you call to the high court, long call, when you go to the long call, the judge will sit up there, then all of you will line up where the ropes one by one call to the front. In front of the long call, the table, there will be 3 persons sitting there, 3 body, what we call. One is AG Chambers Wakil, one is State Bar Wakil, one is Bar Counsel. And when your name is being called, Dennis Chong, you're hereby being admitted to the High Court, blah, 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 roll number, blah, blah, blah. Then each one of them has to stand up of the 3 body and say, no objection, sir, no objection, sir, no objection. They may on that part say, yes, I object. Then you are not being admitted to the High Court. Okay? And you cannot be called to the bar. So they may do that here. This one. So take note, this one, examinable. Now, committee panel, appointment of committee panel, you can read that. So the bar counsel from time to time upon advocate. So these are the people that in the disciplinary committee panel. Not really important. It's just for your information. So that's why I think if you look at the notes, 99. Let's go in 99. Now then, you see here, complaint against ANS or pupil. So they can complain against you as well. Now let me brief you generally. Okay, brief you. Overview, what is the disciplinary process? When a public, it doesn't have to be public, it can be anyone. Okay, even member of the bar also can. They make a complaint against an ANS. The complaint will be sent to disciplinary board. Now, I think I have an article here I've given you, isn't it, that I wanted to read. Okay, later I share with you. And I will show you I think it's the website. Later I'll share with you. So let me briefly explain so that you have an overview. You can write it down if you want, or just general overview. When someone make a complaint against an ANS, the disciplinary board will lodge the complaint. They will take some time to investigate whether the complaint is true or not. Okay? After that, disciplinary board has two choices. Number one, okay, whatever I explain here, it's all in your LPA. Later we read, you see it there. You don't have to memorize. You want to briefly jot down, you also can. If you don't want, it's also in the notes. If you look at the notes in there, 1.7, I written there already. Okay, you don't have to write. If you want, you can briefly, up to you. So basically, I just briefly explain. Once a DB got a complaint, they'll make sure that it's true. And then after that, they have two options. Number one, they can summarily, S-U-M-M-A-R-I-L-Y, and you'll see these words in your section 99 or 100 later. They can summarily decide, meaning the disciplinary boards can investigate themselves and decide what kind of punishment we want. Or, most of the time, the second option, the disciplinary boards will appoint a disciplinary committee. So that's why you see the term DB and DC. DB stand for disciplinary board, DC stand for disciplinary committee. Okay? The disciplinary board will appoint a disciplinary committee. I think there will be 3 persons in there. The disciplinary committee will then go and investigate. They will not only investigate, they will set a date and ask the lawyer and also the complainant to come. And then this lawyer and this complainant can be represented by their own lawyers as well. So as if like a mini trial like that. To come to the place they set, and then they will sit there and ask questions, and they will, exchange documents, do this like a mini trial, but not in the court. Okay, not in the court, in a different kind of setting, in a place they set. So they will do that, and how should they do that? What is the procedure on doing that? Now, open up on your LPA, and you look at legal professions, disciplinary proceeding rules 2017. Okay, I think it's under your statute. Again, this is not provided to you in exam. So do you need to know everything of them? Do you need to memorize? Now, not really, but then there are some important things you need to know. Okay, we'll see, we will go through it later on. I think if you look at the notes, I told you to do this particular chapter together and read it with legal profession disciplinary. You see the first green color relevant section, rules 2017. So we'll read that together in probably third part of the class. So then after that, DC will investigate. And I always tell you, the rules are there to supplement the act. The rules are there serve as a guideline to help the DC what they can do, what they should do. So these rules, all these rules, if the ANS violate same thing, they have to be punished for disciplinary like conduct. So these rules are important. It has the same power like law. So the DC will investigate, follow all these rules. Once they're done already, they will have a decision. Okay? They will have a decision. Let's say their decision by the DC it's to fine this lawyer 100,000. They'll pass back these decisions, all right, to the DB. DC pass back the decision to DB. DB will look at the suggestion by DC and say, oh, DC suggests 100,000. DB then has a choice. He can choose to follow this suggestion by DC, or he can even increase it or decrease it. So the absolute power is at the end is by DB. DB can say, okay, since DC say 100,000, we will follow 100,000. Or if they say, no, 100,000 too much already, 50,000. Or they say 100,000 too less, we should just strike him off the road. Then DB will pass the final decision to the ANS. Then ANS will know, okay, this is a final decision. So it can be the DC suggestion, and the final decision that DB passed to ANS is different, because the final power, it's at DB. Should they follow? Should they increase? Should they decrease? Then you'll pass the decision to the ANS. Then ANS will know. After that, ANS has a choice. He can go and appeal to the High Court. This is a general overview. So now we look at the statute and we dive into each particular section, and you see some of the nitty-gritty. We call it nitty-gritty stuff. Okay? Now let's look at the section 99. Any complaint concerning the conduct ANS or pupil. So same thing, pupil can be, it's the same. Mutatis mutandis is the word. Equally applies to. Shall be in writing and shall in first place be made to the DB, which shall deal with such complaint according to rules. Okay? Then you see. No complaint, this one. Take note, no complaint concerning the conduct of any ANS or pupil shall be inquired. Now, take note English words, inquired and enquire. Sometimes I don't know whether I'm teaching English or teaching law. Enquire is ask, okay? Inquire is a much more formal way. You know what's the ongoing case right now, inquiry? The Zara case in Sabah, isn't it? That's inquiry, inquest, INQUEST. And we will learn that in criminal procedure. Enquire is ask, okay? One of the students I talked to yesterday, and I know you know who you are, because she wanted to sit for the exam in Bahasa Melayu because she's a matured student. And I said, fine. And I said, and because she know that English is a weak point, all right? So sometimes she do ask me question, but she asked me in Chinese, and I said, no. You're not going to ask me question in Chinese. I want you to ask me question in English. Because at least to be a lawyer, your English and Malay must be good. So all of you, if you want to speak to me in Malay, ask me question in Malay to train your Malay, please feel free to do so. At least there's someone that can practice with you. Don't be shy. So I told her, don't be shy. You know, even though she know that her English is not that good, even though the vocab and grammar is not complete, don't be shy. Talk to me and I'll correct you along the way. Then you will learn. If not, you won't learn. At least it's an extra language for you. It's your advantage. Okay? So some of you, maybe you think your Malay is not that good. You want to practice with me? Yes, I speak very fluent Malay. All right. Now, complaint concerning the conduct of ANS or pupil shall be inquired into by DB after expiration of 6 years from the date when the right of action. This is as if like the civil procedure cause of actions. When does it accrue? We use the term. When does it accrue? And you will see that there is a case Lim Kian and Chu Kun when we do that next week civil procedure. Okay, cause of action. Provided where the complaint is based upon fraud of ANS agent, through agent, or the right of action. So if it's a complaint based on fraud, then this 6 years doesn't apply. You see, this 3A means after amendment come in. So I think it gets its idea from this Limitation Act. We will see limitation, and when you do Limitation Act next week, civil procedure, you see almost the same thing. The right of action being is concealed by the fraud or advocate. You don't know. After 10 years only, you found out, what the hell, this guy, fraud me. Then, can you still sue? Can you still complain? Still can, if it's classified under this. Okay, you don't get tested this one in exam, don't worry. They always ask you about the appeal part and the procedure part, and also your legal profession proceeding rules. You need to know the rules, and some cases there. Then after that, okay, now let's look at here. Now, let's look at this one, important. When you read section 100, then you read it together with your legal profession disciplinary proceeding rules to supplement it. Okay? Where a written application or complaint is made or referred to DB, DB shall be satisfied that there is no merits. So that's why I said they will take some time to investigate. Last time, right, when I shared with you, when I work in the Ministry of Health as a drug enforcement officer, sometimes we always get complaint, right? Because sometimes this will complain, this clinic is selling fake medicine, this pharmacy is selling fake medicine, this place is selling this and that. We will take 2 weeks to go with what we call as pengesahan aduan. To sahkan, in Malay, S-A-H-K-A-N, to make sure it is genuine, not some busybody trying to think. So we will, I can share a lot of experience. We will go and act like undercover. Yes, undercover, you heard me right. Can you imagine that? Me as undercover to go and make sure that, oh, it really did happen. If it did, we go back and write up a report, submit to our superior, and then they will plan a raid, RAID raid, to go and investigate that place. So they'll make sure satisfy if there is no merit in the application, dismiss and notify the complainant of the advocate of his decision. Who is the complainant? Complainant means the person that complained. Okay? It can be anyone. It can be you, it can be me, it can be bar counsel, it can be judge, it can be anyone. There is merit. If let's say there's merit, then what should the DB do? Now this is the procedure. Now you dive into the nitty-gritty part. Post or deliver to ANS concerned a copy of the application or complaint together with all supporting documents, if any, furnished by the DB. And request the ANS to furnish its written explanation in quadruplicate. What does quadruplicate means? We have triplicate. Triplicate means 3 copy. Quadruplicate means 4 copy. Quadruple. Okay? Quadruple, 4 copies. Together with supporting documents, if any, within 14 days of the request within such longer time as the DB may allow. Where the ANS does not furnish its written explanation as requested, the DB shall proceed. You see that? Shall proceed. Last week when we looked at studied reading statute, I told you the term. In law or statute, you always see the term shall or may. May means maybe. It's discretion of the judge or the court to do so. Shall, it's they must do. Alright? They shall. But it's also possible shall. They have an option. It depends how they structured that thing. But that is a general rule. Where the ANS has furnished its written explanation to DB under paragraph, the DB shall review the matter, and if it's satisfied that there is no merit, dismiss the application or complaint and notify the parties accordingly. Or if it's still the view that there is merit or complaint, proceed to appoint disciplinary committee. So see, now the general, they will have take some time. Like I said, once the DB got that thing, they will take some time to clarify that complaint is true, they're genuine. Notwithstanding subsection 2 and paragraph 3b, if we are here, if the DB considers that the application or complaint may be dealt with summarily, just now I spelled the word to you, okay? It shall give a written notice to ANS to determine whether ANS agrees that the application shall be dealt. Meaning, they feel that the DB feel that they can do it on themselves. They don't have to appoint a DC to investigate. If they think it is a small matter, we can decide, then they will do it. Okay? Summarily, that's the part. If the ANS fail to respond within 14 days in subsection 4, the DB shall proceed to appoint DC, Disciplinary Committee. If the ANS agrees that the application or complaint shall be dealt summarily, the DB may, having ascertained that the ANS understand the nature and consequences of the complaint being dealt with summarily, proceed to do so. Okay, general, you can understand. After dealing summarily, the parties may impose one or more of the followings. So you see that one or more, reprimand, same like your section 94. So your power to punish, the kind of options to punish is under section 94 sub 2 of your LPA, isn't it? Am I correct? Section 94 sub 2. So you see here, it's almost the same thing. Okay? Impose a fine. So what is it? Suspend or strike. Actually the same thing. Same thing like your section 94 sub 2. Notwithstanding subsection 7, the DB may also make an order of restitution. Restitution. Does it sound familiar, restitution? Yes, from contract. Restitution means return. Return, okay? Return. Restitution of the complainant's money if it's established that such money were or held by the advocate and solicitor in his professional capacity and the complainant is entitled, okay, to return. Before imposing one of the penalties or making an order of restitution, DB shall notify ANS its intention to do so and give him a reasonable opportunity to be heard. Now, before imposing, let's say this is the one that wanted to deal summarily. Okay? So, complaints to DB. DB say, okay, I will deal summarily. So then once they said, let's say they wanted to fine the lawyer for 5,000 ringgit. So they will notify the ANS. Okay? But before they impose the penalty, they already tell them they will give the ANS a reasonable opportunity to be heard. How long is that reasonable? It depends. Normally it's about 2 weeks, I think. It depends on the form, the letter that sent it to it. So let's say the penalty is 5K. Here, you notified it. Before they impose it, so they give in like, let's say 14 days lah. Okay? Let's say 14 days. In these 14 days, the ANS may raise it up to DB and say, hey, you shouldn't be like this. Okay, you should just 2K enough lah, don't 5K lah, or 1K lah. Okay, something like that lah. So after that, then only then they impose it. Okay, that is the meaning reasonable opportunity to be heard. An order of restitution made shall be deemed when ordered and be enforced accordingly. If the ANS does not agree that application be dealt with summarily, the DB shall proceed to appoint. Now you see. So most of the time they will appoint a DC. So all the cases I give to you, they all appoint DC. So later the second session after we break, we go through the cases and also the some of the judicial review parts. So DC, pursuant to 103. The DB may at any stage after application has been received require the production of further documents or explanation. Okay? From either the complainant or advocate or from such person as the DB may require, and the parties shall be provided with such document. Any ANS, any other person who without reasonable excuse fail to produce any of the document shall be blah blah blah. Okay, so you read section 100, then now we are up until the part where they appoint DC already, isn't it? Okay, then after that you move to 103. Effect of DB order, this one you can read on your own. Here, 103A. Is it 103A? You see 103C. 103A. So now you appoint DC. So, complain. DB. DB say, feel that he wanted to appoint DC. Then go to DC. So now we go to DC already. So this summary is in the notes also as well. I'll give it to you. So, very straightforward. Sometimes in exam, they will ask you 10 marks, 12 marks to summarize the procedure. Okay? But sometimes they go a little bit deeper in some of the cases. So where the DB determines that the DC ought to be appointed, ANS has been convicted of offense of criminal breach of trust. Okay, the DB shall as soon appoint a disciplinary consists of 3 members. Alright, whom shall be? Who? Layperson. Okay, advocate and solicitor. Appointment from DB panel. Then, this is the inquiry. So you read this part mainly with the rules. So the whole proceeding, you just treat the whole disciplinary proceeding, you read it together with the disciplinary proceeding rule. If you later after the break, we go through these disciplinary proceeding rules, you will see those rules are how they should conduct the disciplinary committee, the DC, how the DC should conduct this inquiry. Okay, inquiry. Let me see how much here. Okay, let's read this one before we go for a break. The DC shall within 1 month. So you don't have to memorize, but then this is all the things you need to know and often examined. Sometimes they'll give you an issue. The DC sent this on this particular date. Then you go and check one by one. Did he send it within 1 month? Did he do this? Did he notify this? Then you say, oh, they are, the DC didn't follow the procedure. That's why, okay, the ANS can appeal to the court or whatever. The DC shall within 1 month of its appointment, okay, highlight the 1 month or circle it up, commence the inquiry into the written application or complaint and shall make its finding expeditiously. Expeditiously means as fast as soon as possible. The DC shall keep a note of the proceeding. Take notes. Shall keep a note. So must keep a note. Means must write down like a judgment like that. And submit the finding of the notes to the DB. For the purpose of any inquiry, the DC may require the production of the inspection by DC, any book, document, require such person. So this is as if. Like what in civil procedure? If you remember. We read Discovery together, isn't it? On last Thursday. What order is it? Order 24. As if. Okay, as if. Require such person consent to give all information in relation. Require any person whom it considers necessary to appear before it to give oral evidence. Okay. Any ANS without reasonable excuse refuse or fails to produce inquiry relating all these things shall be guilty of an offense. Conviction. Okay. You can read this one. I think you understand. Now, before the DC commences its hearing, in respect, the DC shall post or deliver to the ANS concert a copy written application has been made in support, a notice inviting an ANS concern within such period being not less than 14 days as may be specified in the notice, to give to the DC any written explanation he may wish to offer, which may be additional to any previous explanation he may have proffered under section 100, and to advise the DC if he wishes to be heard by the DC. Okay, this is the procedure. Then you look at the disciplinary proceeding rules to supplement this. The DC shall allow the time specified in the notice to elapse and give the ANS concerned reasonable opportunity. Again, you see the reasonable opportunity to help if it is so desires, and shall give due consideration to any explanation he may make. Okay, a little bit more before we go for a break, I think, because we start a bit late after hearing me talk about 20 minutes. Now, finding and recommendations of DC. Upon conclusion, so this part, basically 103B, you will look at the legal profession disciplinary proceeding, LPDP, disciplinary proceeding, okay, 2017, to supplement the rules here. Right? They will go deeper into the rules. What should the DC do? What can lawyer do? And you see cases in there where the DC doesn't allow this lawyer to do this. The lawyer didn't do this. What is the outcome? Okay, so we read these rules together. Let's say they finish already. So DC will have a finding. So the finding, what is it? The finding you see there, upon conclusion, DC shall record relation to facts according to the facts shall determine. So whether there is no that no cause of disciplinary action exists, that cause of discipline but is none of the sufficient gravity to warrant any punishment other than reprimand or censure, or you see that this is the same like your section 94 sub 2. So it is the same power: suspension, revoke, okay, striking it out, reprimands, okay, all these things, fine. Then they will pass this back to the DB. The DC may, in appropriate cases, addition to recommendations and of an appropriate penalty punishment, recommend that the DB, okay, so he can recommend, it's up to them. So they pass it back. So then you see here, after the consideration of the report of the DC. So this is the part where, after complaints, pass to DB, DB set up DC to investigate. So DC here is the part where all the rules come in, how to do this, how to do that. After that, they will pass back to DB. So now this is passed back to DB already. That's why you see consideration by the DB. After consideration, the DB may make an order affirming or rejecting. So like I said, they can keep the same, increase, decrease, whatever. Or recommendation, and the DB rejects the finding recommendation, the DB shall record the reason for rejections. So the final power is the hand of DB, what they wanted to do. The DB may in appropriate cases impose greater or lesser penalty than the recommended one by the DC. Where the DB does not agree with the finding, the DB shall make an order as it deemed just. Before the DB make an order is likely to adverse against. Okay, take note of this one. There's a case we want to look at here. Before the DB make an order that is likely to be adverse against an ANS under subsection 2 or 3, it shall notify the ANS of its intention to do so and give him reasonable opportunity. So come back to here. Now, let's say DB wanted to, let's say DC say punishment fine 100,000. DB say, no, too little. We wanted to strike him off the road. So he will notify the ANS. Again, then give him reasonable opportunity to be heard. Maybe 14 days, I don't know. Okay. Then the ANS can raise this up with DB. Only then they will enforce it. Or same thing, DC suggests fine 100,000. Pass back to DB. DB say too much lah. We only fine him 5,000 enough. He will notify the ANS, we only fine you 5,000. Same thing, you will also give him a reasonable opportunity to be heard. Then he can raise it up with DB. After that, only then you enforce. Okay? Where the DB makes an order that ANS should make restitution. Okay, that's not that particularly important. Okay, then after that, this part is appealed. 103EA, very often tested. It's if let's say after finish here already, after notify, after reasonable opportunity to be heard already, then start to enforce now. Now, ANS dissatisfied. What can they do? They'll go and appeal under here. 103E, appeal. Okay, now good time to take a break. So we take a 10 minutes break. Then we come back. We continue. I'll see how. Maybe I don't know whether should I continue 103E or should I read the rules. Maybe read the rules together first and the case. Okay? Okay, let's take a short 10 minutes break. Alright, let's continue. Now, what I wanted to do now is to read the legal profession disciplinary proceeding rules with you. Alright, so you got your soft copy in the legal profession. Of course, in exam, I keep stressing you are not given the rules. So you have to remember some of the rules. Now, next week, on Thursday, we do ethics rule, but they are much more to ethics. This one is much more related to the Legal Profession Act itself. But it's very easy to read. It's just I wanted to tell you what are the important things. So you flip to the legal profession. I will share with you again also here. This is from the Malaysian Bar website. Okay, you all have, I told you last week how to access it, isn't it? Malaysian Bar website, they have this in a Malay. Okay, for those that wanted to have Malay, you can have a Malay on top. Here is the English version. So if you look at the rules, they will have show you the form, how does it looks like, all these things. Now, get a highlighter or pencil. Pencil will do probably. Get a pencil. Now you look at the interpretations. Complaints, statutory declarations, complaints, all these things. So you see that rule number 2, this is how we quote. for the first time, when you write in exam, you always write the name in full. Legal profession, disciplinary proceeding rules. If you cannot remember the year, it doesn't matter. So legal profession, disciplinary proceeding rules, and then your bracket, LPDP. Then after that, you don't have to keep repeating the whole name. You can just LPDP, LBTP. So LPDP, Rule 2, R2, R3. So you see Rule 3, on complaint lodged with the director. Director of what? Director of the subsection 5, I think it's a disciplinary proceedings, a disciplinary board. Okay, disciplinary boards. Now that one not particularly important. I want you to look at. Now let's briefly go through. You see Rule 4, contents of complaints, processing fees, so meaning those that lodge a complaint will need to pay certain fees. Limitation period. So you see that just now we've seen that limitation period. This one, 6 years, is also in your statute, isn't it? So I think it's just to supplement that. Duty of director on receipt of complaints, okay, as general, nothing too much. Now I want you to focus on this one, Rule 8 and Rule 9. Now let's read Rule 8 and Rule 9 together. Withdrawal of complaints. A complainant may at any time before a final decision is made by the DB apply to withdraw the complaint in writing to the director by the chairman, okay, shall. So let's say Alex is the lawyer and me complain Alex because I was Alex's client and the lawyer somehow negligent, whatever. So I complained. So the complaint was lodged. So I am the complainant, can withdraw the complaint anytime. Maybe Alex, privately come and say, hey, Dennis, don't like this lah. I promise I'll do it nicely. I'll pay you extra money for that. Then I think. Okay lah, I withdraw the complaint. So I can withdraw the complaint anytime. But you also look at Rule 9, intervention by Bar Counsel, notwithstanding Rule 8. Okay, notwithstanding means it doesn't matter. They don't really look at Rule 8, means they look at Rule 9 on its own. And without prejudice to its right to make a complaint of its own motion, the Bar Counsel may, if it's considered there is merit in the complaint, intervene at any time before the final decision is to be made by the DB and proceed with the complaint as if it was made of its own. So I complain against Alex, negligent, whatever. Alex personal message me and say, Dennis, okay lah, I promise to pay you back. Then I say, okay lah, since you already promised to pay me back, I only want the money, isn't it? So okay lah, I'll withdraw the complaint. Now, once I withdraw the complaint, does it mean the complaint is gone? No more. Possible, but another possible scenario is the Bar Counsel can continue the complaint as if he is the one that made the complaint. You see that? Without prejudice, they make a complaint of his own motion. Even after I withdraw it, the Bar Counsel, if they think they wanted to continue, they can continue. They can make a complaint of its own motion. The Bar Counsel may be considered there is a merit because, technically speaking, this lawyer Alex misappropriated the money. Of course, I'm not lawyer, I'm the client, I just want my money back, and Alex promised to give me my money back. So I think win-win situation, there's no issue. But Bar Counsel doesn't think so. Bar Counsel, it's a council that regulate all the professions. They don't want bad apples. So they may say, yes, that is your private negotiation with Dennis, Alex. I don't care, Bar Counsel. My job is to kick out all the bad apples. If you do wrong, because we don't want this to come and affect our profession and build up the image that the profession is bad. So they can continue the complaint and complaint of its own motion. That's why that is what Rule 9 say. Okay, take note, Rule 8 and Rule 9 often attested. Then after that, this complaint of the register, not particularly important. Now I want you to look at, okay, how to conduct. You see that? The director shall compile the following documents. And then you see time and place. Down here, Rule 13. The DC shall conduct its proceeding at the premise of the DB, State Bar Committee, or such other place as approved by the DB on such date. Now, if you go and Google, you will see, I will put this link as well in the recording today, okay? asdb.org.my. AS means Advocate and Solicitor Disciplinary Boards. So why do they show this thing? Because it's at the, where's our Bar Counsel? Bar Counsel, it's at Dataran Merdeka there. I did my, what do you call it? Legal aid there. I did my legal aid there. So you see that, how to lodge a complaint, downloads, frequently asked question. Now I if you look at the notes today, I said relevant case. I actually leave out one thing here, which I give you here. So if you look at the list zip file, I give you a list of cases, right? And also in there is an article, if I'm not wrong. If you didn't get it, so do remind me. So you see here, this one, we gone through this certificate insurance. We gone through this, you know, the insurance thingy last week. So compensation fund brochure. Now, this one is actually from this website. It is a brochure on frequently asked questions. Actually, you get it from here as well. Okay, but I downloaded it here for you. So basically here, it's all the things that we have just discussed. How do you complain? Where? What are the powers? So all these things will include the statute that just now we summarized, and also whatever we are reading here, the Legal Profession Disciplinary Rules 2017. So it's a good summary for you. Okay, you can read this one, the good summary. So add on here, I left out here the article there, which I've given it to you. I think if you look at here, I said this is an important article to read. I didn't write. I also left out here. Should have write it here. Okay, put it here. This is an important article for you to read to summarize the whole thing. So basically nothing too different. It's just the whole discipline proceeding summarized. So this is the website. So where to contact, how do you write it? You see that building? All right, where do you write? Lembaga Tata Tertib, disciplinary boards. Okay, Lembaga Tata Tertib. So this is the one that you write and complain in. Where is it? What should do? Background, jurisdiction, board members, all these things. So I'll put the link. Now, come back to this one. Now you look at Rule 14. Where a hearing in respect of matter is to be held by DC, the DC shall send a notice A&S concerns, okay, AR registered post. A notice shall specify. Sometimes you get question asking you, they give you like a scenario. So you will have a little bit, you must have a little bit of memory of this rule. So the important rules I just now tell you is Rule 8, Rule 9. And now the important rules is this, Rule 13, Rule 14, notice of hearing. Okay, when should they send this? If they don't send this, they violate the rules. The DC violate the rules. It's prejudice against the lawyer. Okay, time frame for hearing and adjournment. Here, Rule 15 highlight important. Okay, Rule 13, 14, 15 important. I'll go along and I'll tell you what's important. The DC shall complete the hearing and submit the report within 4 months. Now you don't see that just now in statute, isn't it? So now there's something different. So the rules here are to supplement the statute. They must submit within 4 months from the date of its appointment of the committee. The DC may adjourn the hearing from time to time without giving a written notice if the if the adjournment is granted in the presence of the parties, notwithstanding where the hearing cannot be concluded within the period as referred to sub Rule 3, the chairman of DB may grant further extension until DC concludes its hearing, meaning they should grant adjournment. All right, take note of these things. The time for DC to conduct, submit shall be deemed extended, or this thing. Now, Rule 16 also important, highlight it. Absence of party before DC, where the complainant or advocate's concern or both fail to appear. Complainant or the advocate concerned, meaning let's say I'm the complainant, Dennis, Alex is the advocate. Fail to appear before the DC on the date fixed for the hearing. The DC may, upon being satisfied, you see, may, they may be discretion. Upon being satisfied that Rule 14 has been complied, then what is Rule 14? Rule 14 is notice of hearing has SAM. They already know where is it be conducted. Proceed to hear the complaint in the absence without further notice and make its determination and recommendations to DB. Rule 17, important, circle it up, highlight. At any hearing, the complainant and A&S shall have the right to be represented. Like I say, it's like a mini trial, but not in court. Me, I have my lawyer represent me. Alex has a lawyer that represents Alex. Okay, like Alex is a lawyer. Then Rule 18, proceedings at the DC at the commencement, the chairman shall introduce, unless permitted, only the complainant solicitor concerned. When the complainant is a body corporate, all evidence shall be given. Here, the chairman shall direct the complainant at any hearings. Okay, you can read Rule 18, highlight that. But the one that often get tested, okay, is Rule 8, Rule 9, Rule 13, 14, 15, 16, 17. Okay, Rule 18 also highlight, but it's basically a repeat of whatever the statute. Rule 19, important, highlight that. The DC shall compile a record of proceedings, Rule 19 here, consisting of all evidence, including documentary tendered, and shall submit the record with report under Rule 21. Rule 20, decision of a majority to be deemed decision of the disciplinary committee, because there are three persons sitting there. Majority is 2. You only have 2 choice. Okay, 2 against 1, 1 against 2, something like that. Report of the DC. The report shall state the finding, fact, recommendation, and reason. So the report is important. Highlight Rule 21. The report cannot be blindly and say guilty or not guilty, striking out or fine. What is the reason you want to find him? What is the reason why you suggest striking out? Because it's against the rule, he did this and did that. Rule 21. All right? Okay. Others you can read on your own. This one miscellaneous, not particularly important. So again, which one is the really important one? Rule 8, Rule 9, 13, 14, 15, 16, 17, 18, 19, 21. Again, 8, 9, 13, 14, 15, 16, 17, 18, 19, 21. Yeah, that's it. Okay? So you can, for those you cannot find, it's at the back of your Legal Profession Act, isn't it? At the back of the statute is in there. Again, I have to remind you, this is not provided in the exam, so you have to remember some. You don't have to memorize word by word. You don't have to. Don't have to. All right? Don't have to. I'll tell you which one you need to memorize word by word, which is the one on Thursday when we talk about it. You just have to understand what is it, okay? Because it may be a question. Now, we have done this once, okay? You can put aside the rules. Now, come back to the article. Again, this is the website. I'll put a link to the website for you. And then you will have the articles there. You can read the one. Now, let's come to the cases. Okay, shall we come to the cases? We do this second part session on cases. After that, the third session today, we'll move to 103E and 103EA. All right. Now, let's look at the priority, based on the priority. Hu Lin Kon and Wong Weng Wo. Where is my... This one. What is the standard of proof in disciplinary committee? Now, when you study evidence, there are only 2 kinds of standard of proof. All right? There are 2 kinds of standard of proof. The standard of proof, it's either beyond reasonable doubts or balance of probability. In disciplinary committee, the complainants must prove it on beyond reasonable doubt. Beyond reasonable doubt. Okay? Again, like I said, I suggest you, where should you read the help parts? All right, very short, so just read the help parts. So you know where to read, isn't it? So we talked about this already, so I don't think I have to remind you again. So I have to give you a summary. Okay? Why I missed out this one? Let's look at body value. Body value, actually I want you to read the whole case. Okay? Body value is read the whole case. You can write there whole case here, whole case. No need to know the facts, whole case. Sorry, I always have this minor mistake in my notes. I'll make sure, try to make it better. Alright, body value issue is whether the Bar Council could validly re-refer the same complaint after it was dismissed and no appeal was filed, and whether DC has jurisdiction to rehear the matter. Now, the order of the DC dated was filed with the Bar and Registrar, okay? Once the DC dismissed the complaint, it was functions official. Functions official means it has no power anymore. It's advised to the complainant to file a fresh complaint was legally ineffective. The correct remedy for the complainant was to appeal. No such appeal was lodged. So the complainant lodged a complaint. The DC investigate and find that there was no issue. So what should the complainant do? The complainant should appeal. The complainant cannot go and file a fresh complaint based on the same thing again. It's like you go to a court to sue someone for breach of contract. The judge says, okay, acquitted. Let's say no issue lah. Plaintiff, defendant, you're not liable. No case. So the plaintiff go and refile the same case again based on the same set of facts. Cannot, isn't it? By right, you should go and appeal, not go and refile the same case. There was no evidence of a new complaint being filed, and since DC dismissal disposed of the complaint finally, the Bar Council application for a new committee was invalid. So the procedure in here, it's invalid. By right, when the DC disposed it already and say no case, the complainant, you go and appeal. You cannot say, no case. Never mind, I go and file again the same thing, the same fact of case again. You go and investigate a second time. That is what we call as double jeopardy or res judicata in civil procedure. Okay? Once a complaint is dismissed by the DC and filed, it is final enforceable High Court order. Committee becomes function official. The only valid recourse is an appeal. The Bar Council cannot re-refer the same complaint without a fresh complaint. And that fresh complaint, yes, but if it's based on the same set of facts, same issue, Dennis complained against Alex for negligence, cheat me 100,000 for my house buying conveyancing fees. DC say, no issue, Dennis, there was no issue. It was clearly really legal. I dissatisfied. I tomorrow go back to DB, Disciplinary Committee, lodge back the same complaint, same set of facts, totally same again. Then the DC would go and appoint again? No, because the DC already decided, Dennis, you should go and appeal, not go and lodge back the same complaint again. Okay? A disciplinary appointed on invalid application has no jurisdiction and decision is void. Okay, now you know what's the meaning of void, isn't it? In general paper, void means cancelled. Next one. Datuk Sangkara, Lembaga Tata Tertib. Whether appointment of DC by the Lembaga Tata Tertib was valid and whether the applicant's challenge to that appointment was premature and justified. Now you see, I keep starting every case with issue because you don't go and memorize the case, what was the thing, what the facts, or else you have so many cases, how are you going to memorize? Dato Sankara is the case. There is a few cases here we talk about judicial review. Now, I'll briefly mention here or else you won't understand. If you look at section 103 section 103E. Now, open up on your statutes and look at section 103E. What does section 103E says? Section 103E says, any party aggrieved by a final order or decision made by the DB pursuant, shall have the right to the High Court within 1 month of the receipt of the notification of the order of decision. So, once a complaint is lodged, DB think there is a complaint. DB appoint DC. DC investigate. Pass back to DB. Once passed back to DB, DB will decide whether to increase, decrease, or stay the same. And then, pursuant to section 103D sub 4, 103D sub 4, which I've explained just now, give a reasonable opportunity to the lawyer to be heard, maybe 14 days. After 14 days, only the DB will enforce. Only then, if the ANS wanted to appeal, then he can appeal. Then he come into 103E and appeal to the High Court. After that given period of reasonable opportunity to be heard, 103D sub 4. Okay? Again, DC will investigate, got a decision, pass back to DB. DB, let's say, decide to increase or decrease whatever, or stay the same, will tell the DC, will notify the lawyer and give the lawyer a reasonable opportunity to be heard under 103D sub 4, maybe 2 weeks. After that, only the DB will enforce. Only then onwards, if the ANS wanted to appeal, he can come in and appeal under 103E, appeal to the High Court. Now you see that 103E sub 2 deleted. Last time, before amendment, 103E sub 2 there, it says that ANS cannot go for judicial review against a DB decision. What is judicial review? The judicial review, or the review that we mentioned here, what was also mentioned in this Statute Sankara, is the judicial review that we will learn in Civil Procedure Order 53, Rules of Court. So under your chapter 28 that we will study, the last chapter in Civil Procedure, then that is the chapter on judicial review. What is judicial review? Briefly, judicial review is whereby you go and review the decision made by a body that exerts some kind of public function. You review the decision of a body that exerts some kind of public function, or even a person. So you can judicial review, over heard this term, against the Ministry of Health, against the Ministry of Finance, against this minister, against that minister. You judicial review against, the Minister of Health or Ministry of Health. Depends who is the body, who is the person that make that decision. So obviously here, this Lembaga Tata Tertib, Disciplinary Board, is exerting some kind of public function. So they wanted to judicial review. Last time, 103E sub 2 say you cannot do any judicial review against the DB. And now it has been deleted, meaning you can do some kind of judicial review against the DB. But when can you do it? How can you do it? We'll look at it in the third section of the class today. Okay, but I wanted to explain that first, because in this Statute Sankara, when the complainant complained to DB, DB go and appoint a DC. Straight away, he go and file a judicial review to judicial review against the DB why they go and appoint DC. The court say, cannot. You cannot do that. Why? Because even if you wanted to appeal, even if you wanted to judicial review, which you can do now, because 103E sub 2, that particular section that last time say no judicial review, has been deleted, meaning now you can judicial review. You can only judicial review. You can only appeal against a final order. Against a final order, 103E sub 1. So now I touch on a little bit what we talk about later on. Final order or decision made by the DB. So you must allow the whole disciplinary proceeding to complete first. So when is the whole disciplinary proceeding complete? Complaint made, passed to DB. DB investigate and see if it's true or not. Are we still in the process? Yes. Let's say DB wanted to appoint a DC. They appoint a DC. Are we still in the process? Yes. Okay, DC investigate. Pass back to DB. Are we still in the process? Still yes. Then DB, let's say, decide to increase or decrease. Notify the ANS. Are we still in the process? Still in the process. Then give a reasonable opportunity for the ANS to be heard. Is this still in the process? Still in the process. Only after when they have given the ANS a reasonable opportunity to be heard under 103D sub 4. Okay, once they notify the lawyer, okay, we wanted to strike up you off the road. Give him a reasonable opportunity to be heard, maybe 14 days. Only after the 14 days, this decision turned into a final decision. Then, only then, the ANS can appeal under 103E, or the ANS you wanted to judicial review can. Only at that particular time you can do that. You cannot go and appeal and judicial review in between the process, because you must allow the process to complete on its own. This Datuk Sankara, he go and file a judicial review when the DB appointed a DC. Which is, the concept cannot. You must allow the process first. Okay, this is what it means. Procedural steps, so you can see the summary there. Next one. Muhammad Ramli, Abdul Manan, and Lim Chi Wee. Okay. I'll briefly go through the cases here, because these are all the important cases. These are the one under 103E and 103EA. So later when we come 103 and 103EA, we don't have to do that again. Muhammad Ramli and Abdul Manan Lim Chi Wee, this one. Now, this is under particular 103E, which we'll read together later on, together 103EA after the break. If, let's say, the High Court, the ANS wanted to appeal against the decision of DB, who should be the party he appeal against? Can he put the president of the DB or the person lawyer, the person that is sitting in the DC board? No. If you look at 103E sub 7, okay, the DB shall not be cited as a party in any appeal under this section. So here, Lim Chi Wee, used to be a president of the Malaysian Bar. He lodged a complaint with the DB against the appellant, this one Muhammad Ramli, and Muhammad Ramli wanted to appeal. Whether the president could be named as a respondent in an appeal. Why is it respondent? We talked about already. When the appeal, the person called appellant, the person responding is called respondent. Okay? In an appeal against DB order, or whether the proper party was the Bar Council of Malaysian Bar. The complaint originated from the Bar Council and not Lim personally. He only signed in his official capacity. So you cannot put DB as your party to appeal. You cannot put Lim Chi Wee, the president, as your party appeal. You have to put Bar Council or Malaysian Bar. Okay? You appeal against the Bar Council. You appeal against the Malaysian Bar. That is what it means. Okay? So we'll briefly go through it. Now, another case. This one, Ong Kee Kiong and Lembaga Tata Tertib. 1.6. Okay, Ong Kee Kiong, this is the one. Last week I told you, right, Ong Kee Kiong is like the student in the class in the school where they always have problem with the headmaster or the disciplinary teacher. Ong Kee Kiong is a lawyer. He has a law firm, you can Google. But he has a lot of issue with the Lembaga Tata Tertib. Okay? This is the one. After DC got a decision, he passed back to DB. DB notify Ong Kee Kiong. Ong Kee Kiong straight away go and do a judicial review against the DB decision. The court says cannot. Because you must allow the process to complete first. Because why? Because when the DB notify Ong Kee Kiong, the DB will give a reasonable opportunity under 103D sub 4 for Ong Kee Kiong to be heard. You must allow that time to lapse, to finish off first. Only then, Ong Kee Kiong, you can go and appeal or you can go and judicial review. He, during that time, haven't allowed the reasonable opportunity to be heard 103D sub 4 to lapse. He go and straight judicial review. Okay? He go and straight judicial review. Cannot. Now, this one I asked you to read para 63 to 73, right? I think this is, sorry, it's blocking my view, this mic. You see here, alternative remedy. Now, if you read here, you will see they quoted judicial review, the principles as in the principles of judicial review that you will learn in civil procedure under Order 53. It's the same. It's the same judicial review we are meaning. Some judges, some cases will kind of, you may want to ask me, if there is appeal and judicial review, when should we go for appeal? When should we go for judicial review? Because if you look at section 103E sub 2, which I say has been deleted, meaning now you can judicial review. But then you also hear, you say 103E where you can appeal to the High Court. Should you appeal to the High Court, and if High Court, because you can appeal to the High Court, if your High Court give a decision against you, you can appeal back to the Court of Appeal, you still can appeal to the Federal Court. Only after Federal Court you should go for judicial review, or you can go for judicial review anytime. When should you do it? Should we wait? Should we exercise our appeal power first? Once it complete already, then judicial review is the last resort. Should we think like that? Or can judicial review come in anytime? If you read this case, you see the judges, they quote that some of the cases, the UK case, tend to say that if there is an appeal process, you should go for appeal process first. Only after finish already, then if really no more option, you can go for judicial review. I disagree. Why? Because if you say like that, you're as if saying that, okay, we appeal to High Court and then go Court of Appeal, then go Federal Court. If cannot, we still have one more resort. There is no one more resort. Judicial review is on a different footing than appeal. You cannot be saying if after go Federal Court don't have it, never mind, we go judicial review. It's as if you can judicial review against any single decision. Cannot. There are strict requirements how you can apply judicial review. If you look at Order 53 of your Rules of Court, you can, when you wanted to judicial review, it's not as of right, you know. It's not as of right. You need to go to the court to get a leave, a permission. Then you need to satisfy the court. Why should you do so? Now, maybe you can satisfy the court. They say, I appeal already, whatever. Possible. But is it possible that without going to appeal to the High Court, you straight go and do a judicial review? It is possible. It can be done. It can. If you look at all the cases that we look at in civil procedure, yes, they didn't even go appeal. By right, they have the rights to appeal. They can go appeal, but they didn't. They go and judicial review. But when you go for judicial review, you need to give a permission. And that particular time, you need to satisfy the judge that why you didn't go appeal, you come judicial review, your reason must be that strong that the court feels that, okay, you should go judicial review now. So it is possible that you can go straight judicial review. So for this Ong Keng Kiong case, let's say he really allowed the reasonable opportunity to be heard, done, complete. Then he got the options. He can go appeal, or if he really think his case is so strong, warranted, that's the term we use, warranted, warranted, warrant him to go for a judicial review, he can do so. But then he must satisfy. If you look at your Order 53, Rule 2, I think, Rule 2 sub 4, something like that. You see there, it says that you will need a leave. So to me, it is possible. It is possible. You can go for judicial review straight without going to appeal, but you really need a good, strong reason why you should do so. Okay? So you can read this one, particular 63 to 73, and that is what happened in here. What happened in here is that he go and judicial review before the time lapse of that 103D sub 4 that give him a reasonable opportunity to be heard. So I want you to visualize the process. You must give him a reasonable opportunity to be heard. Only after that finish, then the decision is final. Then you can go appeal or you can go judicial review. Okay? Now, this one I want to leave first. I will read together with you third session when we done 103EA. Okay? Or else you won't understand. Now, let's look at some of them. Now, Kasinata Balindra, you can read this on your own, but I think it's a bit long. Is it this case is the long case? Okay, No, I think, okay, I'll leave this on your own. That's why I put yellow color. There's nothing too difficult. It's just whether innocent, okay, this is what, whether an innocent party is still jointly liable for dishonors committed by another partner in a firm, and whether the bar counsel was right to refuse the sigil annua in such. Now, sigil annua, we talk about it, isn't it? Ipso Shan, okay, the case when there is sigil annua, you always quote Ipso Shan. So now, let's say me and Alex, we all partnership, Dennis and Co, Merce and Co, okay, we open a law firm. Alex misappropriated the money. All right. So I'm partnership, I shared the responsibility. Because every year when we wanted to renew the license, I said with a partnership, we will have to submit accountant's report, certified audit, to make sure our money is correctly go to the right place. Let's say Alex misappropriated. So of course, I will also be liable. Okay? Innocent party, I'm the innocent. I'm jointly liable. Decision, Bar Counsel refutes since no clean accountant report. We'll look at accountant report on this day. Accountant report rule, okay, is the rule ARR. Is whereby in every law firm, I just briefly explain, you have two accounts. Sometimes they have more, but generally you must have two. One is office account. One is client's account. Office account is the account that you use the money to pay your salary, to do all these things and that. Client's account is the account that you keep the money where client transfer in. Let's say to buy house, conveyancing. You cannot mix client's account with office account, and use it as if it's like a personal account. Ding dong, change here, transfer here, transfer that. Cannot. Very strict. That's why every year you will have to audit your client's account, office account, and certify by an auditor. Once you have that report ready, you use this report together with your submission to apply for Sigil Annual. If you don't have this report, it means that maybe your client's account is not being audited, then they're not sure whether the client's account and office account mix here and mix there. Did you use the money here and use the money there or not? Okay, so that is the issue. Now I wanted, yes, we have a bit more time. I wanted to share a story with you. I have a friend. I cannot tell who is it, okay? You don't have to go and find out. You will not know who is it. I have a friend. It's really my friend. I'm not lying. It's my friend, okay? It's my friend. She worked as a law firm, and after work, a few years, she decided to quit. So she decided to quit, and she is not practicing, okay? She's not practicing. She's doing some other work. So she has a good friend of him, a good friend of her. That friend is working in another law firm. So another big law firm. So that friend, you know, in law firm, there's always some kind of lawyer that focus on doing marketing just to get more business coming. That friend, he's very good at doing marketing. So that friend, let's call him Mr. A, okay? Mr. A and one of the guy in the law firm, and let's call it Mr. B. In another law firm, now it's in this law firm, there is this Mr. A and with a very high-ranking partner called Mr. B. So they have a lot of lubang to get deals. So they took in this deal. They don't want to bring this deal to the firm they are working because they wanted to keep the money for themselves. However, their license is parked at this firm. So they have to think a way to open and set up a law firm outside so that when they have deal, instead of deal coming to this law firm they are working, they will direct the deal to the law firm outside so that they can earn more money. So in order to set up a law firm outside, you need a license, right? Both their license, Mr. A and Mr. B, is parked in this law firm. They cannot. So Mr. A go and approach my friend. And my friend is not practicing. So my friend, I also don't know why, she go and promise Mr. A, you can use my license. So my friend, okay, borrow the license Mr. A, they set it up and park in an address. So whenever Mr. A and Mr. B got deal, they direct the money instead of going to the law firm, let's say convincing, their deals, the cases go into this law firm set up by my friend. My friend only put a name there. She doesn't actually govern anything. She sort of, by right, it's illegal. Against all the rules we study, it's illegal. Now I want to tell you the reality, what is going on out there. So my friend also set up the office account and client's account on behalf of Mr. A and Mr. B. So Mr. A promised that of every deal, Mr. A and Mr. B promised of every deal they brought, instead of going to the law firm they're working, they come into this law firm that my friend's name on it, they give a certain percentage to my friend. Again, it's illegal, touting, ethics rule. But I want to tell you this is reality going on, okay? So my friend promised. After 6 months, I asked my friend. My friend didn't even get 1 cent of the deal. Okay, I said, but he promised you. I know it's illegal, whatever. Okay, let's not talk about the ethics rule. Let's talk about reality. I want to know what is reality going on. My friend didn't even get 1 cent. Worst of all, he find that he cannot log into the client's account and office account anymore. My friend and Mr. A are good friends. Mr. A go and privately change the password of client's account and office account, telling my friend because she doesn't want to bother my friend to do, every time do transfer, need her to go and initiate approve, to keep things simple. And my friend also realized Mr. A started to mix between client's account and office account. Sometimes he took money from client's account to use on his own, and then office account put back. A mess. And I told my friend, you must stop this immediately, or else if someone complain, if you got into trouble, then Bar Council come, your license will be in big issue and problem. I told my friend that. I said, you must stop it. You must stop now. That was the last conversation with her, I think in May. And I haven't heard about it since then, so I don't know. Well, if I see her anytime, and then I will update you all. Okay? So I'm going to tell you something. So this is something reality going on. Okay, a lot, not like rare, a lot. Right. Lim Chi Hui and Wong Chin Hun. What is it about? Okay, what is the extent of court scrutiny when reviewing? So I want you to read para 30 and 34, particular on where the court says this. This one. When an ANS go and appeal to the High Court of the Disciplinary Committee, when will the High Court or Court of Appeal or Federal Court says, DC, you do something so wrong, you didn't follow the rules, you're prejudiced, that's why I allow the ANS appeal? When will it come to the point? Number one, possible if the DC really didn't follow the legal proceeding rules. For example, in the legal proceeding rules just now when we read, the ANS, the complainant must be represented. So if the DC say, no, ANS, you cannot be represented. No, ANS, you cannot ask question, whatever, then it's blatantly prejudice against the ANS. Then very likely this case can be overturned by the High Court. But the High Court also said, we will not go into so detail and interfere with the decision of DC and DB. Unless it is so wrong, you didn't follow rules, a prejudice. Because what should be the standard of an ANS is much better to leave it for you as a profession body, DC and DB, this group, to decide on its own. The High Court say we are outsider. We shouldn't go and interfere so much with your decision to say ANS should behave like this, ANS shouldn't behave like this. That is for you all, the body, the Bar Council, the Malaysian Bar, the DB and DC to decide. But we will allow the appeal and change the decision if we find that, let's say DC, you didn't comply with certain procedure. The rules say you need to do this, you didn't do this, you didn't allow him to do this, then we will allow. But on what kind of standard moral obligation that an ANS should behave, that one, we leave it to you. DB, DC, Bar Council, Malaysian Bar. Okay, that's what they say. Next one. Madis Perguruan Syed Ahmad Imdas. Whether an ANS and solicitor must be given opportunity to be heard when a DB intends to impose a different punishment than the recommended, what is the meaning of adverse? We talk about 103D sub 4, isn't it? Once the DB have a decision whether to increase or decrease, they will have to notify the ANS and give a reasonable opportunity to be heard. But if you look at 103D sub 4, 103D sub 4 says, notify the ANS of its intention to do so and give a reasonable opportunity. Okay, where before the DB makes an order, 103D sub 4, that is likely to be adverse. When you think about the word adverse, it's as if worse, right? So it is as if saying that if DC suggests fine 100,000 and DB say, no, I want to strike it off. They notify the ANS, then they must give a reasonable opportunity for him to be heard. Only then they will enforce, because now from fine to striking off, it's like get worse. But what if the kind of scenario where the DC suggests fine 100,000, DB say no, we will only give him a warning letter. So it seems that from fine 100,000 to give warning letter is like becoming better, right? It's not becoming adverse, right? It doesn't come into the word adverse. So in this kind of scenario, when the DB notify the lawyer, should the DB also still give a reasonable opportunity to be heard for this ANS to be heard under 103D sub 4? Does it come under the word adverse? The answer, the court say yes. Regardless of worse decision or better decision, the DB that will give out, you will still need to give an ANS a reasonable opportunity to be heard. Pushpam Subramaniam. Okay, now this one I think I'll leave it on your own, nothing too difficult, very short case. So whether the appellant has been denied the right to be heard when a DC is suspended, you read the rules. All ANS have the right to be heard in your proceeding rule. But in this case, it was not the fault of DC. It was the lawyer. The lawyer, he adjourned many times. And the DC really complied with all those rules, send notice, whatever, but the lawyer didn't appear. It is the lawyer that didn't appear. So it is the irresponsible conduct of the lawyer. So DC has no choice but to continue. But then the lawyer later come and say, hey, I was not there. You cannot proceed without me. But the DC say, we have given you so many opportunities. We have notified you, we have adjourned, yet you still didn't come. It's your own problem. It's not my problem. I comply with all those rules. That is the issue. Okay? She was condemned unheard, but you see that? You can read this case on your own if you want. Very short case. Now, another few. Ding Xiu Ching and Ling Pik Ho. Of course, this four, it's green color. So if you have time, you go and read it. Ding Xiu Ching and Ling Pik Ho. Like I said, you find a lot of this case, Ding Xiu Ching and Ling Pik Ho, because they have a lot of case, long time. Whether High Court failure to deliver written grounds for itself is sufficient. Whether the grounds, okay, Court appeal asks whether the absence of written ground deprived High Court was not sitting, okay, by affirming the High Court clearly chose not to interfere, which was within. So the issue was whether the written grounds, whether the High Court so what happened in this is here's they go to DC, all right. DC, I think, have a report, then go up to High Court. High Courts allow I think allow the appeal, okay? But the High Court didn't write any judgment. So is it an issue or not? Now, of course, when you look at the disciplinary proceedings, the DC must have a written judgment. Now it's not. They're not complaining about DC no written judgment. They're complaining about High Court. So they said, on appeal from DB, the High Court judge acts as an appellate capacity. Appellate capacity means as a party that listens to appeal, not as a trial judge. Now you see this word trial judge, appellate capacity when we do, in very often, I'll explain to you. When you use the word trial judge, it is that the case originally started there. For example, a case start in session court where the trial happened in session court, chief exam, cross exam, re-exam, then session court is the trial judge. When you lose, you appeal to the High Court. High Court is the appellate court, appellate capacity. Okay? In disciplinary proceedings, the whole disciplinary proceeding is done in the DC. Just now we see that, disciplinary committee. So DC, that's why must have a written judgment. Once you have a judgment, they pass back to DB, got ready, pass back to you. If you're dissatisfied, you go to the High Court. Is the High Court a trial court now? Is the High Court the trial judge? No, because the whole disciplinary committee proceeding was not done in the High Court. It was done within the DC. So High Court is not a trial judge. High Court now is only coming in as appellate court to listen to an appeal. Appeal from where? Appeal from the ANS that complain against the final decision of the DB. That is what it means. They are not a trial judge because in High Court, no witness will come. Now you have to make clear, because I need to explain all these terms to you. If not, your CLP journey will be very hard. You will not understand here and there. So I try in the beginning of the course to explain as much term as much possible for you. When you start a case, when you look at court jurisdiction, you can either start a case in magistrate court, session court, or High Court. These three cases only. You will not be able to start a case in Court of Appeal. You will not be able to start a case in Federal Court. Federal Court, there's an exception. Okay, I will not talk about exception. You won't touch about that. So let's say today, I sue Alex for breach of contract. Should I start in session court, magistrate court, or session court, High Court? We will look at that next week in civil procedure, court jurisdiction. It will depend on the amount of money that you sue and also some other things. Let's say you decide to start it in session court. Okay? Session court, it's the trial court. This is the court where you will tender, use the word tender, T-E-N-D-E-R. Tender evidence, ask witness to come, litigation, chief exam, cross exam. This is where all the thing will happen in session court. This is your trial court. If you got a decision, you dissatisfied, you wanted to appeal, then you appeal to the High Court. In High Court, no more witness will come. There is no more chief exam, cross-exam, ask the witness to come, no more. In High Court, when you appeal to the High Court, judge will sit there, you as the losing party and the party you're appealing against, appellant respondent, you will tender your submission, your written submission, or depends on oral submission, depends on what the judge asks. And the judge will look at it, look at your oral submission, and then decide. No more witness will come, no more chief exam, I put to you this and that, like you watch in the movie. No, nothing like that will happen. All these things will only happen in the trial court. And the trial court can only be either magistrate, session court, or high court. Depends on the amount of money they sue. So let's say you start in magistrate court, you lose, you go and appeal to high court. Okay, we'll talk more about that in next week. And you lose, you go and appeal to court of appeal. That's it, 2 level. If you start a case in session court, you lose, you appeal to high court as well. You lose again, you appeal to court of appeal. That's it, finish, done. Cannot already, 2 more level max. If you start a case in high court, you lose, you appeal to court of appeal, you lose again, you appeal to federal court. That's it, max, done, 2 level. So understand the word trial judge. So what they are saying here is that whole disciplinary proceeding was done in the disciplinary committee. So once you lose, you appeal to the high court. High court only listen to appeal. There's no trial, there's no witness. So there is no need for them to have a written judgment. That is what they say. So because I need to explain it, or else when you read the case, you might find it a bit difficult. Okay, next one. Where are we? This one? Ding Siu Jing and Ling Pik Ho. Citra Debbie and Nangalingam. Citra Debbie and Nangalingam, I'll leave it to your own because there is actually a year, 2018 or whatever, that the question was set very similar to this Citra Debbie and Nangalingam. Because if you see this Citra Debbie and Nangalingam, you'll find that when the DC conduct the disciplinary proceeding, they violate a lot of rules. They don't allow him to do this, don't allow him to do that. So the A&S go and go and appeal to the High Court. And the High Court says, DC, you prejudice against the A&S because you didn't comply with the rules. So what rules they didn't comply? Right to be heard, cross-exam, burden of proof, all this sort of thing. Okay? Next one, Majlis Peguam Cheng Eng Hing. So help part means you read the help parts. Whether DB has the power to remit back to the DC for considerations after DC has already made its decision? Cannot. What happened in this case was this. A complaint was lodged. Lodged ready, DB go and find out it's genuine, go and appoint a DC. DC already go and investigate, then DC has a decision. So when the DC has a decision, they pass to the DB. DB feel that DC didn't do his job properly. DB feel that DC is not correct in his decision. So the DB go and throw that thing back, like reverse back to DC and ask DC, you go and investigate again. Cannot. You cannot do it. After DC pass the decision back to DB, you cannot throw back the case to DC. DB, you can either agree with DC or you increase or you decrease. That's it. Okay? Functions official means you have no power there. Padma Raja Malvaganam, JMC Ventures. Now, this is the one. You see here. Never mind. Whether the plaintiff who had been struck off the roll had shown special circumstances justifying state of execution. Now, maybe you don't understand that, but once we deal with civil procedure, let's say in civil procedure, let's say the High Court found Alex liable. Alex, you have to pay Dennis 1 million ringgit. Can Alex say, Judge, you hold that judgment first because I wanted to appeal to Court of Appeal, so I don't pay Dennis first? Can he do so? He can, but he must have good reasons to stay of execution. He must have special circumstances to stay the execution of judgment. Same thing in DB. You see, here, whether the plaintiff who has been struck off the roll has ordered to make a restitution of 3 million, had shown special circumstances justifying a stay of execution of DB. So DB says, Alex, you need to pay Dennis 3 million back of the money. Can Alex say, wait first, I wanted to appeal to High Court. Maybe High Court will overturn, so I don't have to pay Dennis first? Can he say that? He can, but he must really show good reason why the judgment should stay. So the principles here are the same principle like you look at when we do appeal chapter in civil procedure. Special circumstances, and there's a case for that, a landmark federal court case called Cosma Palm Oil. Okay? So like I said, this is a green color. If you got time, then you read lah. If you don't have time, then never mind. But the reds and the yellow, important. Okay, it's a good time to take a break. After that, we will read 103E, 103EA. Then after that, you can look at your notes here first. And we'll go through this note together. And we then will look at the case of Ong Keng Keong and we'll see how far we can go, because I have one more short thing. This one is very straightforward case I want to read, and quite often tested as well, but nothing too difficult. So I want to read this together with you as well. Okay, let's take a 10-minute short break. Right, let's have a look. Appeal from final order or decision of the DB. Any party aggrieved by a final order or decision of DB shall have the right to appeal within 1 month of the receipt. So now, last time I told you this one, it says here no judicial review. Deleted. So now you can go for judicial review. And like I said, should you go for appeal first? Should you go for judicial review? Most of the time, if let's say there is a case, it satisfied the judicial review requirement. Not every case can go for judicial review. If let's say Alex sue Mr. Lee for breach of contract, Alex judicial review cannot. The judicial review it must be against a decision of a body that exerts public function. So not every case can go for judicial review. So I'm talking about in terms of civil procedure. If let's say a case classified, it can go for judicial review, all right? You also have the choice of appeal, all right? Then it depends on you what you want to do. Do you want to go for judicial review? It's up to you. That's up to the lawyer now. Do you think you have a strong case for judicial review? Because if you want to go for judicial review, you will need a permission from the court. Most of the time, they go for appeal first. Most of the time. That is why if you look at the case just now I shared with you, he said it clearly, and I agree with some of the things they said, that normally when there is appeal, they go for appeal. Judicial review should be like when you have nothing to go. But I don't want you to confuse it as if after federal court, you still can go for judicial review. No, it's not that way. But what he is saying that if a case classified as you can go both way, judicial review or appeal, you should go for appeal first. That's what the case says. And some of them I agreed some of them. So, but to me, it is possible. If you don't want to go appeal, you want to go straight for judicial review, you must satisfy the requirement. You just have to satisfy the requirement. Possible. The appeal shall be by way of originating motion, set out grounds. And now I want you to take note of this one. In a general civil procedure matter, if you start in magistrates, you lose, you go to high court. Now you'll be surprised. There are CLP students before the exam still confused that magistrate court lose already, go and appeal to session court. There is no go to appeal session court. Because in the court jurisdiction, let me briefly explain here. You have high courts, court of appeal, federal court. Down here, what we call as subordinate courts. Sorry of my handwriting. Here, you have sessions and magistrate like this. So magistrate lose, you go high court. You lose, you go court of appeal. That's it, finished, done, complete. Session courts, you lose, you go high court. You lose, you go court of appeal. Done, finish. High court, you lose, you go court of appeal. You lose, you go federal court. Done, finish. Here, you see something different. In this act, it says that if you lose, if you have a decision that you're dissatisfied, you can appeal to the high court. If you lose, dissatisfied, you can go court of appeal. If you're dissatisfied again, you can go federal court. But even though there's 2 layers, but you have to remember there is one DC here. So as if there is like 3 layers there. It seems like, isn't it? Because here, this is the trial judge. This is the trial judge. This is the trial judge. So then you 2 level, 1 level, 2 level. Is this the trial judge here? No. This is not the trial judge. Here, we don't call the trial here because by right DC don't conduct a trial. It is the inquiry. The inquiry is here done at DC. You lose, you dissatisfied, you go high court. You dissatisfied, you go court of appeal. Dissatisfied, go federal court. That is why when you read particular statute, you see how they word. If today the statute is drafted this way, any appeal against the decision of high court shall lie to the court of appeal, and they didn't draft this thing. Let's say they didn't draft this thing. Then you will follow the civil procedure way of learning that this is DC, right? inquiry, you dissatisfied, you go High Court, you dissatisfied, you go Court of Appeal. That's it, done. So that's why they must draft this out clearly to say that you can go federal court. When we do appeal chapter and seal procedure, you will see one or two cases that there are certain particular act that didn't clearly write this down. The case name is Nga Leno Marketing. Okay, so I just want to show you that as if you have one more extra level that you can go out. The disciplinary board shall not be cited as a party. We talked about that already. Now I want you to look at this one. Often tested. As the word suggests, section suggests, 103EA. So you have a LPA first time amendment that add 103E. Second time amendment that add 103EA. Now there was many issue previously because yes, you can appeal to the High Court or judicial review against a decision. Take note, it must be a final order of decision of DB. There were a lot of issues previously whereby during the disciplinary committee didn't comply strictly with the rules. For example, your legal profession disciplinary proceeding rules. They must allow the the ANS to be represented, okay, must send them a notice within this particular date, isn't it? Just now we look at rule 13, 14. Where is it now? Time and place, notice lah, allow them to right to legal representations, right to represented, right to hear the complaint, absence, adjournment. So there were a lot of issues previously whereby the DC didn't comply with this thing, but they have no place to raise this complaint. What I mean is, the ANS is being investigated by DC. During the disciplinary committee, a disciplinary proceeding, the inquiry, the DC didn't comply with all these things. The DC said, maybe the ANS said, I want to tender this document. DC said cannot. Then DC wanted to raise this issue, but they have no place they can raise this issue. Why DC don't allow me to tender this document? Why DC don't allow me to be represented? By right, your rules say you need to be represented, allow me to do this and do that. So there were a lot of issues previously where this thing happened, yet the ANS cannot do anything. They can only wait until a final decision and appeal to the High Court or judicial review. So later on, they add on this section. You can make any objection from any decision which is other than final order or decision made by the DB. Now, I want to read this statute with you. If you don't understand, don't worry. You look at the notes I give you. Okay? Where any party is aggrieved, who is the party? ANS. Decision, order, ruling, or direction of the DC or the DB, other than the final decision made by the DB referred to in section 103E, aggrieved party may file an objection in writing respect. Okay, may file an objection. So they say you must file an objection early on. Okay, just take it as it is. It's a bit not that straightforward to read this particular section, and I'll give you notes in that. Where the objection raised in respect of composition or participation of member of DC. So for example, you have a complaint, DB make sure that it's a genuine complaint. Appoint a DC committee. And just now we say DC committee has 3 people sitting in there. Let's say you realize one of the persons sitting in the DC committee is your enemy. You used to like the same girl, something like whatever. So obviously he has prejudice against you, isn't it? He will be biased. Can you raise an objection? Last time we cannot. Last time we don't have avenue. We don't have any avenue. We use the word avenue. Okay, we don't have any avenue or place we can raise an objection. Now we can go this one. That's why whether composition, you object against the person sitting there because he's biased against you. Or the DB, as the case may be in meeting, proceeding, and inquiries, the procedure to deal with the objection shall be set out. After objection raised, so you must raise the objection first, has been dealt with, the DC or DB, as the case may be, shall proceed until its completion. After the ANS raised the objection, the next step is you must allow the DC or DB to continue with the proceeding until its end. Where the objection raised is not related to matters referred in subsection 2, meaning other than composition. Other than composition, because this one is composition. Other than composition, The DC or DB, as the case may be, shall make such decision, order, ruling, direction on the objection as it deemed just, and shall proceed with the inquiry until its completion. Again, proceeds inquiry until its completion. Where the inquiry proceeding referred to subsection 3 and paragraph 4b is before the DC after the completion, the DC shall make its recommendation to DB pursuant to 103C, or before the DB after the completion shall make its order pursuant to 103D. The order of decision of DB under paragraph 5b shall be suspended from coming into effect or 30 days from the date order on such further time as the court may allow an aggrieved party to apply to the court for a review. The review here means judicial review. Okay? If an aggrieved party does not apply for review, the order of decision of DB shall take effect immediately upon expiration of 30 days. Nothing in this section shall preclude an aggrieved party from raising any objection in any appeal he may file under 103E. Now, my question for you is this. If I were to give you a question and I ask you, so now A and S is dissatisfied that he was not allowed to tender a particular document in the disciplinary inquest, what is the procedure pathway for him to appeal and review? Tell me then. Your answer is in here, 103EA. But how do you read it? Last year, I have one of these students. He has a very constructive argument with this area where I really appreciate the way he looked at it. And I say, I agree with him. And the way he analyzes is very fantastic. So how do you? Now look at the notes. First of all, is judicial review available for A&S to challenge? Yes. Before the amendments, okay, they say that you clearly cannot judicial review. The provision has been deleted. All right. So with its deletions, now remedy is now opened. Section 103EA sub 6 also states that A&S may apply for judicial review to challenge the decision of DC or DB other than the final decision. When can A&S apply for judicial review to challenge final decision of the DB? Now, we talk about Datuk Sankara, we talk about Ong Kee Kiong. Okay, that is where you must allow the whole disciplinary proceeding process to finish first before you can go for appeal or before you can file a judicial review. So we talked about that already. Should an A&S appeal a final decision of the DB before resorting to judicial review? Now, judicial review here seems the legal principles are same, Order 53. There is no rule or case which require applicant to first exhaust the appeal process before resorting to JR, even though JR is normally considered a remedy of last resort when no alternative remedy is available. Under 53 order, leave of court must be obtained. So if you want to go for JR where you can appeal, then you really must satisfy the court the need to pursue JR at that particular stage. And there are cases in there when we do judicial review in your civil procedure. Can an A&S apply judicial review to challenge a decision other than a final decision of the DB? Now we are talking about 103EA. Yes, A&S may apply for judicial review to challenge a non-final decision of the DB. When we look at 103E, it is a final decision of the DB. 103EA is whereby during the process, the DC doesn't allow you to do this, DC doesn't allow. Can we file a judicial review to challenge the decision of DC not allowing to tender this document, not allowing it to be represented? Yes. 103EA sub 5 allows such challenge. Example, against the composition, example, against any order of decision made during the disciplinary proceeding. So that's during the process. Why you don't allow me to tender this? Why you don't allow me to do this? Why you don't allow me to do this? Because there was many issues previously. So the amendment and add this in. However, under section 103EA sub 1 or sub 2, the advocate and solicitor must first raise an objection to the DB. If no objection is raised at the stage, the remedy cannot be pursued later. This is with regard to 103EA, whereby can you file a judicial review against a decision other than final decision of the DB? Then we look at 103EA, you can. You can because 103EA, but you must file, okay, objection. Actually, it's DB or DC because you look at 103EA. may file an objection in writing with the DC or DB. You can write here DB or DC. Okay, you must file an objection early on when the issue pops out. So now what is the procedure? When can ANS apply for judicial review to challenge a decision other than final decision of the DB? Pursuant to 103EA, ANS may challenge the decision other than final. However, this can only be done after DB has made its final decision under 103D, provided that the ANS has already raised an objection under here. If no objection is raised at the disciplinary stage, the remedy of JR will not be available later. Now, this again, it's judicial review against the decision other than final decision of DB. Now, take note, don't confuse. When DB got a complaint, passed to DC, DC investigate, pass back to DB. DB pass back to ANS, notify him, give him reasonable opportunity to be heard. Then that is a final decision. That final decision, then you can appeal under 103E or you can judicial review, no problem. Now, DB got a complaint. Appoint DC. DC investigate. And during DC investigation, they don't allow you to do this, they don't allow you to do that. You feel it's so unfair. Can you challenge and judicial review the decision of DC? Now it is not a final decision, you DB, you know. This is not a final. But during the process, you challenge the decision of DC. Can you judicial review against him? Then we look at 103EA. You can, but you must comply with the procedure. What is the procedure? The procedure, one of the first thing is you must file an objection in writing. So now the issue is, what is the procedure? So now let's read this together. How do you read the statute? This is also another key. Now let's give you a scenario one. What is the pathway? This is my step-by-step pathway for you. Let's say during disciplinary proceedings, ANS not allowed to cross-examine. So you are the lawyer. Lawyer Alex was not allowed to cross-examine. He's the one got complained, but he was not allowed to cross-examine. So now what should he do if he wanted to judicial review against this decision of DC that doesn't allow him to cross-examine during disciplinary committee? He must first make an objection under 103EA sub 1. He must make an objection. You must. 103EA sub 1, that's how you read it. Then after that, what? After he make an objection of 103EA sub 1, you look at 103EA sub 4, where the objection raised is not related to matters referred in subsection 2. Are we referring to any composition matter? No. Now he is objecting that DC doesn't allow him to cross-examine in the in the inquiry proceeding. So he first make an objection pursuant to 103EA sub 1. Then after that, what? Then 103EA sub 4. DC will deal, with that, shall make such decision, order, ruling, direction, or objection is deemed fit. So once the objection is raised with DC, DC will look at the objection and make a decision. After he make a decision, you must allow the DC to continue with the inquiry until it finish. Again, I repeat, during disciplinary proceeding, ANS not allowed to cross-examine. So this is not a final order, you know. This is not a final order like we said 103D. So now you wanted to object and judicial review against this decision of DC not allowing to cross-examine. What can you do? You must first make an objection pursuant to 103EA sub 1. After that, you look at 103EA sub 4. After you raise an objection, the DC will consider your objection. After he consider your objection that is under 103EA sub 4 sub A, then you must allow the DC to continue with the inquiry until it's finished. After he finish, then you look at 103EA sub 5, where the inquiry or proceeding referred in subsection 3 and paragraph 4b is before the DC. After the completion of the inquiry or proceeding, the DC shall make its recommendation to the DB pursuant to 103C. So after that, DC done complete with the inquiry, DC will pass the decision to DB. The whole decision of the inquiry. That is, go back to the original disciplinary proceeding. Remember the original proceeding? We said, when you have a complaint, you lodge with DB. DB check if it's genuine. After genuine, then he appoint a DC. DC will investigate. After got a decision, pass back to DB. Remember that? So now we are in the DC process where one of the things they do, you dissatisfy. So if you are dissatisfied, you object first, 103E8. After you object, DC will deal with your objection. Then you continue pursuant to 103EA sub 4 sub B until it finish. After it finish, then you look at 103EA sub 5A. Then DC will pass the decision back to DB, 103D. We go back to 103D now. After that, you can judicial review 103EA sub 6. The order of decision of DB under paragraph 5B shall be suspended from coming into effect for 30 days from the date of order of decision or such further time as the court may allow and enable aggrieved party to apply to the court for review. Here, you are reviewing against the decision of DC not allowing you to cross-examine during inquiry. Because you make an objection here, so that's why this pathway is available to you. That's why just now when you say here, I say here, if you didn't make an objection here when the DC don't allow you to cross-examine, then this pathway is all not available. So the first thing first, when they did something that you dissatisfied, where it is not a final decision of DB, you must make an objection 103EA sub 1. Then you look at 103EA sub 4. They'll deal with the objection, then proceed. After that, 103EA sub 5, DC finish the completion of the inquiry. Then you go back to the original pathway. They will pass the decision back to DB, 103D. Then because you already make an objection here, now you can raise and do a judicial review under 103EA sub 6. They allow you 30 days to do so because you are the aggrieved party. And here, your judicial review against the decision, against a decision of the DC not allowing you to cross-examine. This is the pathway. You look at it. Scenario 2. A and S object on the composition of DC. So they say, hey, the person sitting there and listening to my inquiry is my enemy. He has bias against me. Then how? Then you look at 103EA sub 2 and sub 3. So 103EA sub 2, where the objection raised in respect of composition or disciplinary board, as the case may be, the procedure to deal is what? After the objection, sub 3, the DC or DP, as the case may be, shall proceed with the inquiry or proceeding until its completion. Again, you raise the objection that the person sitting there is the enemy. It will be biased against me. Okay, they take note of your objection already. They will deal with it and then they will continue with the inquiry until it finish. After that, you go to 103EA sub 5A. After that, what? They got to finish the decision, where is it? Yeah. They got a decision already. They pass back to DB. Pass back to DB 103D. Then because you already make an objection here, then now you can judicial review under 103EA sub 6 against what? Against the composition of the person sitting in a DC that may be biased and prejudiced against you. You are not judicial reviewing against a final decision of DB, but you are judicial reviewing against any other thing other than final decision of DB because you already raised raised an objection here. You are judicial reviewing against the person sitting there may be biased against you. Scenario 3. DB make a ruling. Okay? Disciplinary board make a ruling. A and S dissatisfied and object within 14 days. EA sub 1. So now DB make a ruling, which is not a final decision. Maybe during the process, DB got a complaint, go and check whether it's genuine or not, pass to DC. Okay? DC go and investigate, then pass back to DB. Possible scenario where DB got a complaint, DB feel they can summarily decide on it. They don't have to appoint DC. So meaning this investigation will be done by DB alone. So now during the investigation, they do it on their own and then they don't allow this A and S to do this and do that. And the ANS feel, hey, it's prejudice against me. But this is still not a final decision under 103D, so he cannot appeal. But is there any other way he can object or raise an objection or judicial review against the ruling made during the process by this DB? Yes, he can. DB make a ruling, he dissatisfied, so he must make an objection early on EA sub 1. That's why when you see your 103 EA, you see they always write final order or decision other than final order or decision made by the DB or DC. Also, you see 103 EA may file an objection in writing in respect of such decision, order, ruling, or direction with the DC or DB, because it can be an investigation is done by DC, or it can be where the DB feel they don't want to appoint DC, they can decide on its own, then the investigation is done by them. So here now, let's say it's investigation done by them. They make a ruling. You dissatisfied, so you must object early on 103 EA sub 4. Then you go to 103 EA sub 4. 10 EA sub 1, then 103 EA sub 4. DB dealt with the objection and proceed with the inquiry. Then you go to 103 EA sub 5 sub B. Before the DB. Because you see 103 EA, just now we see A is before the DC. Now it's DB. So now 103 EA sub 5 sub B before the DB. Then after that, this thing after that, you go back to 103D. You can add on here 103D. Okay, technically speaking, why I didn't write 103D is by right here, you see all this scenario 1 and scenario 2, DC will pass back decision to DB. DB will tell you, right? Because now this decision is made by DB. So there's no passing back to DB. He got a decision already, then he will tell you, notify you the decision. Now, because you make an objection early on here, so now you can go for judicial review under 103 EA sub 6 against one of the ruling made by DB during the process. Scenario 4. During disciplinary proceeding, ANS is not allowed to cross-examine. The ANS didn't raise an objection. He said, hey, DC, why you unfair against me? Why you don't allow me during the inquiry to raise to cross-exam, to tender this document? Then he just said like that, but he didn't do anything. He didn't make an objection pursuant to 103 EA sub 1. Then, if he didn't make an objection, he cannot later apply for judicial review to challenge the decision of not allowing him to cross-exam during inquiry under 103 EA sub 6. The only remedy now is to appeal to the High Court. So he has to wait. He has to wait until the final decision by the DB passed back to him. Then he will appeal under 103D. Appeal to the High Court. Okay? Sorry, not 103. 103E, sorry. 103. Appeal to the High Court 103. And raise the issue that he was not allowed to cross-exam on grounds of appeal under 103 EA sub 8. Because if you look at 103 EA sub 8 now, let's look at 103 EA sub 8 says what? Nothing in this section shall preclude an aggrieved party, who is aggrieved, the ENS, from raising any objection under this section as ground of appeal in any appeal he may file under section 103E. That's the only way. So can he go for any judicial review against the decision of disciplinary committee not allowing him to cross-exam? He cannot. But he can appeal under 103E. Or he can judicial review against the final decision of DB, the one we said just now. He cannot judicial review against the decision of the ANS not allowing to cross-examine because he didn't make an objection here. So this remedy of 103 EA sub 6 is not available to him. So in that kind of scenario, after he got a final decision of DB, he can go and appeal and raise this objection as one of the grounds of appeal. Or it's possible, if it's satisfied, then he can go and judicial review against final decision of the DB. So we read Dato' Sankara case. We read Ramli. We read. There's one case here called Ong Kek Kiong again. Ong Kek Kiong again. Now you see this case. whether the applicant seek judicial review of DC and DB decision, whether the applicant could seek judicial review of the DC and DB, dismissing is striking out application and refusing to provide grounds or notes, or whether such interlocutory decision were premature and not susceptible to judicial review. So talk about judicial review. Courts may intervene for illegality. So when we do judicial review under Order 53, you will see when will the courts intervene. The courts will intervene under illegality, irrationality, okay, premature, procedural impropriety, all these things, okay, all these things. So 103EA say introduced to prevent abuse of interlocutory. You see the way they structure 103EA, they allow you to raise the point, but they don't allow you to raise already and then stop there. They allow you to object, then after that they must allow the proceeding to continue, because if you object then everything start there, all proceedings will start there, cannot move on. They allow you to say, hello, why you don't allow me to cross-exam? You raise your objection already, they heard your objection. It's like giving you an avenue to voice your concern. Okay, I heard your objection, right? We take note of your objection, now let us do our job. You continue until you finish. Okay, after that, if you want to go and judicial review against our decision not allow you to cross-exam, then you have 30 days to do so. It's like giving them like a way to voice their concern and avenue, at the same time doesn't disrupt the process of disciplinary proceeding. So in this case, this is agreed principles. What happened was he didn't make an objection in this case. I think he didn't make an objection. I think he didn't make an objection. One thing, he didn't make an objection. And also, when he raised this thing, it was still on the old law. You see that? Since the complaint dated 2013, predated the 2000 amendment, the 103EA section only comes in later on. So the 103EA section doesn't apply to him. When he made that complaint, but when the complaint was made at that particular time, 103EA there is no 103EA yet. It hasn't amended and come in yet. During the trial, I think 103EA suddenly comes in already. But then his complaint was dated here, before the amendment. So they have to follow the old law for him, whereas he doesn't have the remedy of 103EA, something like that. Okay? Now, what you need to know in this particular section is you must familiarize with this judicial review, non-judicial review. And also the pathway. Understand it from the statute. See how I read it. Now, I write this, draw this down to you is because I want it easy to follow along. Like I said, in a year's time, nobody is going to have these notes for you. You'll be standing at the courts and the judge will look at you and say, tell me then, what do you think? And that's where your skill of reading statute must come in. How do you read them? How do you move from this section to that section? Okay, now do we have time? Now I'll briefly go through this because I think this one I can leave it to your own. Now let's look at section 105. Okay, a few more things I wanted to look at is, I want to take note of this one. Cause against frivolous and vexatious applicant or complaint. If the DB find that the complaint is just bullshit, whatever lah. The complainant, Dennis complained Alex. Dennis is just, don't like Alex, so he just simply make a complaint. Then they can find me. Okay, the DB can find me. So you take note of that once. I think we've done this one already. Okay, I want to look at this. An A&S may voluntarily apply to remove their own name from the role. Okay, now you know the role. So may subject apply to court, they have his name removed from the role. So you can, I want you to take note of a particular session. He can apply himself and remove his name from the role. Okay. An applicant shall be heard by the judge sitting in an open court. Open court means anyone can go in. Most of the cases are done open court, but sometimes there are cases are done in the chambers. No order shall be made under this section if the judge is dissatisfied. No order shall be made on the application under this section if the judge is satisfied that disciplinary action is pending. The conduct on the hearing, the judge may make an order. You will see one of the questions actually past year exam that said this. He said he was a lawyer in Malaysia in the role. He was also a lawyer in New Zealand. So he is practicing in New Zealand, but because he in New Zealand, he got some kind of disciplinary proceeding. He was struck off the road in New Zealand. So he feel very, like inferior. Is that a word? It's like feel bad lah. So he feel that he cannot. He doesn't. What do you call it? He feel that he cannot be a lawyer anymore. Because he do bad things in New Zealand. So now his name is still on the roll in Malaysia. Can he remove his name from the roll? Then 105. He may remove his name at voluntary. He go and remove his name from the roll. Okay, very rare you don't really see these things. Now I also want you to look at 107. High Court may restore an ANS, assuming a ANS has been struck off the roll, meaning they remove him from the roll because he did something so bad. After few years, can he apply to put his name back on the roll? Yes, he may. 107. The High Court may think fair and reasonable at any time order the registrar to restore to the roll the name of ANS which has been removed. Any application be restored shall be by originating motion, support by affidavit. Motion means you move something. Move not as in move, push something. Means you move a thing in the court. Okay, we say move something in the court. Before the High Court. Notice of the motion shall be served to the bar counsel which shall be represented at the hearing of motion, shall place before the court a report which shall include copies of the record of any proceeding as a result of the name ANS was removed, struck off, a statement of facts which have occurred since the name was removed or struck off, and which opinion of the bar relevant to the considered. Any appeal against the decision shall lie to the Court of Appeal and therefore Federal Court. So then listed down, you can go here. Okay? The reason why they write this thing, like I said just now, is so that they give you like one more layer. And also, if they don't write this thing, we will have to fall back to look at CJA or SCA. If we fall back to Courts Judicature Act, which governs High Court, Court of Appeal and Federal Court, or SCA, Subordinate Court Act, which govern Session Court or Magistrate Court, you will see clearly the particular section 28, section 68, section all these sections when we look at civil next week, that clearly say in order, let's say to go to in order to go to Federal Court, they will say like this, the wording. Federal Court has the power to listen to appeal from Court of Appeal, which is a case originated from the trial jurisdiction of High Court. That is what they will say. You don't have to write down anything. Next week when you do civil, you will go through that. They will always say like that, the wording. They will say Federal Court has a power to listen to the appeal of Court of Appeal and also from a case that originated from the original jurisdiction of High Court. What does originated from original jurisdiction of High Court means? Means this case gone through the full trial here. Witness come, evidence standards. So that's why this is called a trial court. Then after that, you lose, you go for Court of Appeal. Then if you lose, then Federal Court can listen. Because if they don't write this here, you will fall back to CJ and SCA. Then you will see that this whole thing of restoration of disciplinary proceeding doesn't originate in High Court. There is no trial there. Then how does it apply? They were stuck there. That's why you see when they draft the act, that's why they purposely put this here. So now I want you to have more skill. Now you see the step or not. You're not in that LLB, that kind of thingy, big picture overview already. Now you're going into very detailed particulars. So you see sometimes I take very long to explain what is trial, because if I don't explain that, you don't understand. You start there, and then start there, you don't understand, then everything is start. Okay? So if you don't understand anything, you can always ask me, so I can clarify for you. Then only then your journey of CLP makes much easier. So maybe one day you'll be one that draft this thing. So then you know the skill of drafting. Why do they want? Because when I read this particular statute, I was thinking, why do they want to write this? Because we all know you go Court of Appeal, go Federal Court. Then I think, it must be because of this. Now, there are few cases there I want you to look. And this is your homework. And it's not hard to read, but it's very often tested. So I'll give you a summary there. When let's say Alex got struck off, after many years, he wanted to go back to the High Court. What are the considerations the court will look at before allowing him to be restored to the role? These are some of the considerations, and there are many cases there, but I give you these 4 cases. And very often, you also tested 10 marks on here. So now you have to explain. This is very easy. This is the LLB thingy. This is the LLB thingy, very easy. So what are the things? What are the considerations? Then you will use the case to help you explain. So Avtar Singh, for example, what is it? The reasoning? Restoration is not automatic. Must show that he has rehabbed. Okay? Must show he has turned over a new leaf. Next one, Gabriel Rupananda. What is it? Applicant rely only his own assertion without producing credible independent testimony. So let's say Alex wanted to go back to the court. He just say, I already turned over a new leaf. I didn't cheat again. The court will not just listen to his one-sided story. Do you have any testimony to support you? Then if the testimony is, let's say, from a high-ranking judge, then of course it's much more convincing. You ask a testimony from Dennis, someone nobody, don't write a testimony to support Alex, then they say, who the hell is this Dennis? How is it reliable and convincing? Okay? Rehabbed, turn over a new leaf. See all these things? So this one you can read on your own. Now, of course, I told you where to read the case, so please try to read the case here. Okay, the particular paragraph, all right? Murali Achand, what is fair and reasonable, which is under your section 107. Okay? What is the key principles the court will look at? What are the reasoning? This is a very straightforward, easy LLB level thingy. Tabanadan, same thing. What is it? What's the reasoning? Serve his sentence, not enough. What is fair and reasonable? So you can use, so if there's a question in there, all right, you will explain section 107. You will use these few cases to help you articulate. Okay? You'll use these few cases to help you articulate to get that 10 marks. All right, I think today is not that particularly difficult. It's just that you have to get your brain with it, okay? Get over that disciplinary proceeding, and then it's very straightforward. And I draw out that particular flow for you already. And see how you read the statute. That's why I want to focus one class just for this one, because it's very often tested. Very often. Almost every year you have question in there. Okay? Right, shall we stop here? Just nice 12:30. Tomorrow we will have discharge and remedy, probably another heavy class. Then we have Wednesday and Thursday much more chill. So next week, then we will go full class already, 4 full class. Then you will see some of the things. Then you will know how you're coping, what should you do, your time management, okay, and what you can do. All right, okay, I'll leave here and let you all go have lunch. Okay, bye-bye everyone, bye.